work under the contractor. Amullo was knocked down by the motorcycle, as a result of which he fell down, became unconscious, and died. On the basis of complaint lodged by the de facto complainant, Narayan Chandra Sao, the IGRA PS case number 223 was started by the IGRA police under section so and so of the IPC against the offending driver. Ultimately, said case ended in charge sheet bearing number so and so, dated so and so. Police has seized one motorcycle, RC book of motorcycle, DL. Also, the post-mortem report goes to show that he died due to accident. So it has been clearly established that he died due to knocking down by motorbike. The said vehicle was covered by insurance policy. On 11th April, Sub-Registrar of Death and Birth, Gram Panchayat under IGRA, certified that Amulyo died. It further reveals that income certificate issued by the contractor, the owner of the car enterprise, victim Amulyo, was an employee under the contractor earning rupees 3,000 per month. He was aged about 50 years at the time of death. He also earns 1,004 from cultivation of lands. It has been admitted by PW1 that initially wrong number of the motorcycle was quoted. PW2, Hemant Kumar Sao, eyewitness of the incident, has seen the accident caused by offending motorcycle. It was running at a high speed in a rash and negligent manner, caused accident to victim Amullo, resulting to his death. So motorcyclist was solely accountable and responsible for such death. PW through Vikas Roy, supporting the claim, repeated and reiterated that the said accident was caused by rash and negligent manner of driving a offending motorcycle, while Amulya was returning home. The claimants could not show on having any landed property of the victim by producing certified copy of the record of the right. Thus, this court finds that the claimants have failed to establish that the victim was earning rupees 1,000 from cultivation of land per month. The claim cannot be relied upon without documentary evidence. Rather, this court finds that there is substance on relying upon the documents based on which it can be said that the victim was earning rupees 3,000 per month as worker under the contractor who has issued the income certificate in his favor. Thus, claimant is entitled to rupees 3,000 into 12 into 13 multiplier less 1/3 is equal to 3,12,000. Besides that, 9,500 under general damages are also entitled. I'm at page 20. Claimant cannot get any medical expense. Thus, the sum total is C12 plus 9,500 is C21,500.
Yes.
This court refrains from awarding interest on the awarded amount if the said amount is paid by the insurer within 3 months from the date. In default, claimant will be compensated by awarding interest at the rate of 12% per annum from the date of filing of the claim application till realization. In Ranu Balapal and others versus Vani Chakravarti, now issue concluded. Now he deals with it after concluding, deciding, and delivering judgment. Now your lordship will see how this it has been dealt with. Different judgments are now been dealt with after delivering the judgment. And Ranu Bala and others versus Vani Chakravarti, 1999 ACJ, it has been held that explaining section 169 of the Motor Vehicles Act that some miscreants fired at random on a vehicle due to which driver and passengers were injured. Driver lost control, vehicle met with the accident. One passenger sustained fatal injuries. No evidence before the tribunal that the deceased died because of bullet injury. But deposition of widow of the deceased that there were head injuries, injury to chest and other parts of body because of accident. Tribunal thus allowed compensation under no fault liability, but dismissed the claim under fault liability. It's been held by the Honorable High Court that it is a summary inquiry and the tribunal is not expected to take or to reduce the nicety of civil or a criminal case. So, the case has been remitted to the learned tribunal to take a broad view of the whole matter and dispose it of in accordance with law. In view of the above decision, the court has taken a liberal approach towards the claimant for losing their bread earner due to accidental death. In this case, the involvement was not in doubt. I do not know why this reference was brought in here. Absolutely, of no use. Page number 21 in Abati Bejburia versus Deputy Director General Geological Survey of India, 2003. It's been held on explaining section 166 and 168 of the Motor Vehicles Act as the principles of structured formula as provided in the second schedule should not normally be deviated from guidelines for determination of amount of compensation. Amount of compensation should be just and fair. This was young man, stable job, liberal view taken regarding his future prospect. This was drawing 3,500 per month. Higher estimate of yearly income of 45,000, not out of place. 1/3 of gross income towards personal living expense was deducted. Thus, amount of 30,000 was determined as loss of dependency. Said amount was capitalized by applying multiplier of 15. Compensation of 4,50,000. In the light of, this is on quantum again, this has got no reference because 3000 is already decided. In the light of the Honorable Apex Court decision, this court has followed the structure formula and has awarded 3,21,500. In Bestu Ram versus Anant Ram, 1990, it's been held pedestrian was standing away from the middle portion of the road, was hit by the bumper of a fast-moving truck and was injured. But the respondent denied the vehicle was involved in the accident as it was elsewhere at the time of accident. An eyewitness deposed to have noted the number and name of the owner of the vehicle. Eyewitness deposed about the rash driving of the truck, and the truck driver stopped the truck for a couple of minutes after hitting the injured and then ran away with the truck. No evidence was there to contrary. Evidence was produced by the respondent to establish that truck was elsewhere in his unbelievable accident was not reported to police. The tribunal found that it has not been established that the accident took place with this truck, but the appellate court set aside the tribunal's finding and held that the accident was caused by rash and negligent driving of this truck. Relating to the accident, it's been held that accident was not reported to the police. There was adverse inference, injured, and the eyewitness did not report the accident to the police. The doctor who treated the injured did not make a medical legal case. No adverse inference can be drawn out of the failure to report the accident to police by the injured. In the instant case, we are now drawing a parallel from this inference, learned tribunal judge. In the instant case, the de facto complainant lodged FIR against the driver of the offending vehicle. Police has made investigation and submitted charge sheet against the accused person. So the prima facie case of running over of the vehicle was established by the police. In Manjeet Kaur and others, was in the state of Punjab, 1997. It's been held on explaining the section 166 of the Motor Vehicles Act relating to rash and negligent driving. The deceased passenger, while alighting from the bus at bus stop, fell down from the bus and was dragged by the wheels when the driver drove the bus rashly and negligently. This is succumbed to the injuries sustained by the accident after about 2.5 months. The state of Punjab denied the factum of accident on the ground that neither an FIR was lodged nor any criminal case was registered against driver. Passenger traveling with the deceased supported the claimant's version. Widow of deceased went to lodge report, but report was not written, and she sent written report to SSP. Bed head ticket of the deceased containing that deceased sustained injuries in a road accident was found. A specific mention of road accident in leave petition was submitted in the office of the deceased. Deceased died because of the injuries sustained by him in the road accident as a result of rash and negligent driving. So the tribunal awarded the compensation. Here again, the involvement was confirmed. In the instant case, this court already found that there was a rash and negligent driving of the offending motorbike, culminating death of the deceased Amul. In Virat versus Mohan, 1994, Punjab, it's been held on explaining section 166 relating to rash and negligent driving that in accident cases, FIR is often lodged in a haste and the same cannot be substituted for the evidence giving exhaustive version of the occurrence. A statement before tribunal are made on solemn affirmation, whereas FIR is never lodged on solemn affirmation. Thus, the claimants were awarded to 68,000. I repeat the line: statements before tribunal are made on solemn affirmation. Your Lordship has seen what statements have been made on solemn affirmation. And learned tribunal judge, in spite of having the inquisitorial jurisdiction, took note of that, seen that, and simply it obliterated everything. In the instant case, claimants have been able to make out the case against the opposite party insurer for accidental death of the offending vehicle covered with insurance policy. In Manjula versus Bombay, 2000, it's been said that widow of deceased stated that deceased was 29 years. Postmortem report supported version of claimant. No evidence led in rebuttal. So deceased was aged 38 years, was not sustainable. The deceased was held aged around 29, 30 years. It is not related to our case, nothing. Page number, internal page 10, running page 24. Banking upon these decisions, it has been submitted that the claimant all through investigation have claimed the age of victim Amullo to be 50 years. No investigation agency has disbelieved the above age of the deceased. Thus, the age of the victim was known to the claimant is acceptable unless a strong piece of evidence is forthcoming to the court. Having regard to the above decision, this court finds that the compensation awarded to the relatives of the victim, that is, the claimants, are just and proper, following the schedule for compensation for third-party fatal accident injury cases. Claims appended to second schedule under section 163 of the Motor Vehicles Act. All the points are decided in favor of the claimants. The claim application succeeds. Order. Claim case allowed on contest without cost. Insurer shall pay rupees 3,21,500 to the claimants within 3 months. In default, 12% interest on the date of filing of the claim application. Milord, I have shown your lordship, Milord, the entire set of documents. Income, Milord, I am not disputing 3,000 rupees. Assessment, Milord, I am not getting into those aspects. Save and accept, Milord, those default interest, which is not permissible under the Act itself. That was absolutely wrong. It should be, Milord, 6%. I believe, Milord, in this case, I do not know from where they will get, Milord. They may go to the owner of the vehicle, because if owner doesn't come, and Milord, his vehicle was involved, it doesn't comply with 134, then let him pay. This second vehicle, Milord, 7214, who has been, Milord, held to be responsible. And, Milord, wherein, Milord, we prove before your lordship with the insurance company, prove before your lordship, Milord, that this vehicle was not involved. And owner does not dispute that. It does not inform the police. It does not inform the insurance company. And, Lord, he gives his vehicle to be implanted. So in this case, this is a fit case where your lordship will not use my lord's discretion and say that since you allowed your vehicle to be implanted, then you make payment. Let now, Milord, I'll take your lordship to the judgments which I rely upon.
Yes.
I'm thankful to my learned friend, but he's suggesting which one to show, but I'm showing that.
My learned friend is saying the same that only on that. This is first time place for me. Let me see. Other one matter, you argued that the plan with Mr. Joyto Banerjee. I know.
You get your opportunity.
Okay.
Milord, this is, in this case, Milord, tribunal awarded
Yes.
Milord, tribunal awarded 21.38 lakhs, 21,38,000. High Court, Milord, said it is a brazenly false case. High Court disbelieved. Milord, there were 2 eyewitnesses. A lot is said, Milord, about this preponderance of probability. Forget about preponderance of probability. There were 2 eyewitnesses before the court. 21.38 lakhs awarded in favor of the claimant. I could say it is a brazenly false case. Milord, the award was set aside. The claimant went to Supreme Court. That's, Milord, the same ground. Preponderance of probability. 2 eyewitnesses. Nobody can dispute eyewitness. Supreme Court said, go away. Nothing doing. What High Court has said, that is absolutely correct. But I'll take your lordship to this. Milord, the judgment, Milord, is the very first page, starts in the beginning. Milord, at the bottom, the Punjab and Haryana High Court by judgment dated 6 September 2010. Milord, I'm the next page.
Yes.
Reversed a decision of the Motor Accident Claims Tribunal, Rewari, dated 6 February 2001. The tribunal awarded compensation of 21,38,000 together with interest at the rate of 9%. High Court reversed the award on the ground that the appellants had set up a brazenly false case to manage a fake involvement of the insured's vehicle. The deceased was a person by the name of Ram Kanwar. Ram Kanwar was died. His brother Satvi was the owner of a tractor. Case of the claimants which was sought to be established through PW1. Bhavani Shankar was that 12 January 95, he together with 2 others, namely Rohdas and Ghanshyam, that is PW2. Lordship will see PW1, PW2. These are all eyewitnesses. Were proceeding in a tractor driven by Dharampal from Sejanpur to village so-and-so. Ram Kanwar signaled for the tractor to stop. Ram Kanwar died, your lordship, can you remember?
Yes.
However, the tractor was driven in a rash and negligent manner, result of which Ram Kanwar, it ran over Ram Kanwar. Besides adverting to the evidence of PW1 and PW2, the alleged eyewitnesses, the tribunal adverted to the FIR lodged against Ram Kanwar under section so-and-so, in holding that the accident had occurred and that it was caused with the negligence of the tractor driver. Tribunal observed. FIR, Exhibit PA, death report of Ram Kanwar and unrebutted evidence by the petitioner. It is proved on record that the accident took place on 12 January on account of rash and negligent driving of tractor number so-and-so. And in the accident, Ram Kanwar died. Accordingly, issue is decided in favor of the petitioners. The issue was very clear. Two witnesses, my lord, FIR, everything is there. There is a delayed FIR, my lord, in this case of my lord 33 days. But your lordship knows, my lord, delayed FIR of 33 days in most of the cases, my lord, honorable courts are saying that not to give, my lord, much importance. Here, Supreme Court has taken note of everything. My lord, paragraph 3. In appeal, the High Court has adverted in significant detail to a number of disturbing facts. The lordship will see, my lord, I would rely upon this term disturbing facts, which have emerged from the narration of the case by the claimants. The High Court has adverted to the relevant aspects of the evidence. Thus, there are disturbing facts that emerge from the narration of the case by the claimants. In this case, deceased was Ram and his brother Satvir was the owner of the tractor. PW1 Bhavani, who claims to be the eyewitness, says that he, along with two other persons, namely Rodas and Ghanshyam, that is PW2, were in the tractor driven by Dharampal. Ram, deceased, was stated to have traveled in the same tractor, also from Bahrod to Shahjahanpur, and alighted at Fauladpur for some work and asked the driver to pick him up on his return. Tractor was returning at 6:30 p.m. Deceased Ram was standing on the road while he signaled the tractor to stop. Tractor ran over the deceased in the rash and negligent driving of his driver. It is stated that he was run over under the wheels of the tractor. Deceased was said to have been taken immediately to hospital at Kotputli, where he was found bleeding excessively. Dr. Mehra, PW4, who was at the hospital, has recorded this fact in OPD slip and said to have referred the deceased for further treatment at Gurgaon. It is not known whether the deceased died at Gurgaon or had died at Kotputli. Admittedly, no postmortem has been conducted. Now, your lordship will see significantly, no postmortem was conducted. High Court also noticed the fact that though the accident took place on 12 January 95, complaint was lodged only on 15 February 95. As regards the evidence of the driver, High Court noted that while at one stage he had stated that deceased was brought dead, at another place he stated that he was referred to the government hospital for further treatment. Contradiction in statements. The circumstance that no postmortem was conducted is an extremely significant aspect of the case, which in our view has justifiably weighed with the High Court. Moreover, the High Court found that if there were 3 passengers in the tractor, all of whom had known that driver Dharampal had by his negligent act run over Ram Kanwar, the most natural conduct would have been to lodge a complaint. The person who died, the brother of the owner, the person who died was a brother of the owner of the tractor. Hence, fact that complaint was not lodged for nearly 1 month is significant omission in this case. High Court also noticed that there were no hospital records to indicate from the nature of injuries that had occurred due to an accident of the nature alleged. Deceased was conducting a transport business with his brother and was an income tax assessee. The fact that proper medical records were not available has, in this background, weighed with the High Court. Besides the above aspects, the High Court has found that the assessment of compensation by the tribunal is perverse. On a careful analysis of the judgment of the High Court and the material on record, we find no reason to take a view at variance with that of the High Court. The reasoning contained in the award of the tribunal was perfunctory. The tribunal failed to notice crucial aspects of the case which have a bearing on the question as to whether the death of Ram was caused as a result of the accident caused by the tractor. Each of the circumstances relied upon the High Court is germane to the ultimate conclusion that a false case was set up to support a claim for compensation. The appellants have not been able to displace the careful analysis of the evidence by the High Court and the findings which have been arrived at. For the above reasons, we find no merits in the appeal. Appeal is dismissed. No response. Willard, this judgment of Supreme Court, Willard, demolishes this entire theory of this preponderance of probability. Someone said, and since nothing is coming to the contrary, so it has to be believed in totality. For the claimant, the legislature, the act may be beneficial, but not at the cost of insurance company, not at the cost of exchequer. If one is entitled to, one should get. Here also, 2 witnesses. Absolutely, given the case was demolished. Supreme Court said that no, in spite of 2 witnesses being there, in spite of the FIR, delayed FIR of only 33 days being there, we are not believing this. It is an absolute false case. Thereafter, I'll state with come your lordship, to this on the normally, our High Court, on the ground of this when the evidence is there, is a little circumspect, and they are a little, my lord, I would use the term, my lord, very knowingly, my lord, and deliberately. They are a little towards, my lord, claiming that somebody has died. Somebody, my lord, has been suffered.
Leniency is there.
Leniency is there, my lord. I would say, my lord, even if I take it 51-49, then 51 is always there. So, my lord, I'm always fighting against odds. My lord, I'm always trying to, my lord, go, my lord, a step further to prove my case, because the leniency, as my lord has rightly pointed, I'm grateful to your lordship, my lord, it is always there. So, my lord, in spite of that, two different honorable judges, my lord, very recently, my lord, within 1 month from this date, my lord, Justice Vivash Pattanayak as well as Justice Vivash Ranjan Singh, in two of the cases, my lord, have of this involvement, my lord, false involvement or non-involvement of the vehicle, my lord, have held that this vehicle was not involved and insurance company is not liable to me. I'll show those to you. I'm not going, my lord, much.
Yes.
And my learned friend is so happy, my lord, because he appeared in one of those where he lost. Your lordship, may I just find it over to your lordship. My lord, in this case, Kalpana Vikas. My lord, in this case, my learned friend appeared, my lord.
Yes.
My lord, the learned tribunal judge had dismissed the claim case on the ground of non-involvement. My learned friend, Mr. Punik, preferred this appeal. This appeal was also dismissed on the ground of non-involvement. Your lordship will kindly note below. In this case, below there were two eyewitnesses. Again, exactly like the case before your lordship today. The owner also admitted the evidence. My lord, there's accident.
Yes.
Still, my lord, the honorable court, my lord, came to the finding that no, it is again a false case, vehicle implantation, insurance company cannot be made liable. Delayed FIR of 25 days. My lord, paragraph 16, if I take your lordship straight away. My lord, paragraph 15, my lord, at internal page 6. My lord has got it, my lord. My lord, the facts, my lord, I have given your lordship, my lord. Now, my lord, the judgments, my lord, I'll deal with. Learned advocate Mr. Ponik, appearing on behalf of the claimants, tried to evaluate the evidence on his own way, in his own way. In support of his contention, Mr. Ponik relied upon, my lord, Mita Samanto. Mita Samanto is, my lord, the mother judgment that no adverse inference can be drawn, my lord. No, there was no other evidence was brought forward. So, Mita Samanto was brought forward, and this Ravi versus Badri Narayan. My lord, this is the mother judgment, Ravi versus Badri Narayan, with regard to delayed FIR.
Yes.
My lord, in Ravi versus Badri Narayan, there was a delay of 33 days. Supreme Court said that it is not so germane to the fact because the delay was explained properly, and therefore we would say that this delay is condoned, and we find that vehicle, because there were other evidences, my lord, vehicle was involved. So this is Ravi versus Badri Narayan. My learned friend has cited these two judgments, my lord. In opposition, my lord, so and so, relying on the judgment passed by the learned tribunal, has pointed out serious contradiction among two eyewitnesses. He also raised the issue of delay of 25 days in lodging FIR. He also pointed out the evidence of PW4, who testified about the accident on 19/4/11 by the involvement of his vehicle owner. Your lordship, kindly take note, two eyewitnesses, owner. Thereafter, not any alleged accident to have been taken place on 23/3/11. In support of his contention, my lord, he relied upon Anil, my lord, which is here before your lordship. My lord, Mita Samanto, the favorite of my lord, the claimants. Supra dealt with the case where eyewitnesses testified about the accident when truck in question struck the victim who was driving his motorcycle, and in fact, he collided with a light post standing by the side of the road. Honorable High Court took note of the FIR, having no reference to the truck, as FIR maker was not the eyewitness. In that case, owner of the truck did not defend by adducing evidence. Badri Narayan dealt with the issue of delayed FIR in terms of chronology of incident embedded in first information report. The opinion of Honorable Supreme Court were found that there was no delay in lodging FIR. Badri Narayan is confined to only that aspect. Ravi versus Badri Narayan. Para 19. In Anil, my lord has gone through the Anil, my lord. The Honorable Supreme Court came across the serious contradiction in the evidence adduced on behalf of the claimants. My lord, I am not reading this, my lord, because my lord has read that just now, my lord. Anil, internal paragraph 4. Then, my lord, paragraph 20. Now I come to the case in hand. On careful scrutiny of the evidence of PW1 to OPW1, I noticed few mischiefs in the evidence on the following issues. PW1 wife stated that owners of the offending vehicle were co-villagers, but she never disclosed the accident to the owners. Rather, she informed the accident to Panchayat. Unfortunately, none came to the court from Panchayat to substantiate the evidence of PW1. It's also not explained why PW1, as to the reason why she did not inform the owner of the vehicle caused accidental death of her husband. She further stated that SUBHENDU, PW2, informed her about accidental death of her husband in front of Adarsha Hotel on GT Road. PW2 was also a co-villager of PW1. P. SUBHENDU, PW2, claimed himself to be the eyewitness to the accident. He lodged FIR at Gulsi on 19/4. This is a delayed FIR. But PW2 could not explain the delay of 25 days in lodging FIR for the accidental. He specifically stated that vehicle fled away after the accident. In spite of having knowledge of owners, co-villagers of the offending vehicle, he never informed them about the accident caused by their vehicle. It is not explained in his evidence what prevented him to inform his co-villagers who were the owners of the offending vehicle. C. PW3 also claimed himself to be an eyewitness to the accident. In his evidence, PW3 testified that offending vehicle did not run away from the spot even after the accident. You will see the contradiction. The first one said ran away from the spot. This witness comes up and says he did not run away from the spot.
Yes.
Therefore, there is serious contradiction among the two eyewitnesses regarding fleeing away of vehicle after the accident. D. Sheikh Abdul Rahman, OPW1, that is the owner of the vehicle, stated that the accident took place on 19 April 2011. He stated about relationship as co-villagers with the claimants. He stated he did not maintain any garage register and driver fled away with his vehicle after the accident. He informed Gulsi police station after 2-3 days of the accident and police registered a case. His vehicle was seized after 2 days of the accident. He further stated that he did not place any claim to the insurance company regarding damage of the vehicle in the accident. No intimation to the company. Therefore, evidence of owner OPW1 did not corroborate the date of accident stated by other witnesses examined on behalf of the claimants. That apart, the fact of information to the police by the owner and registration of case by the police have not been substantiated by any document. In the backdrop of these facts, I am the view that 25 days delay in filing first information report is fatal. For the reasons aforesaid, there is hardly any merit in the appeal. It is dismissed. Moot point is contradiction of eyewitnesses. Accident happened, today. Owner comes up and says it happened, after 2 days. Two eyewitnesses, one comes up and says that the vehicle was there standing at the spot. The other eyewitness comes up and says that no, it fled away after the spot. All three admitted the involvement. But this contradiction, weighed heavily on the Honorable High Court, and then said that no, I am not going to believe this. And that is why this claim case was dismissed. It was dismissed by the court below. It was dismissed by the Honorable High Court because of these contradictions. The other judgment of this Honorable High Court. Here also, there was, in this case, there was delay of more than 300 days of FIR. Eyewitness was there. Owner admitted that yes, my vehicle was involved. This was also disbelieved, and the Honorable High Court, His Lordship held that no, claimants are not entitled. In this case, the claimants were awarded compensation. Just like the case before Your Lordship, insurance company preferred the appeal. His Lordship accepted the argument of the insurance company and held that no, this vehicle was not involved. The insurance company was exonerated. Absolutely on the point of these contradictions. The vehicle has been implanted and this vehicle could not have been there at the time of accident. Just like our case. Your Lordship, kindly come, to paragraph 10. I will not trouble Your Lordship much of the facts. It's at page 6. At page, Your Lordship, kindly go page 4, I'll just show the judgments which were there. Page 4, Your Lordship has seen in the bold,
Yes.
Anil is there. My Lord has seen that. Kalpana Rohidas is there. Your Lordship has seen that.
Yes.
Your Lord, in the next page, page number 5. Your Lord, my learned, Mr. Roy was appearing. You know, he has shown this evidence, the judgment, Basti Kasim. Your Lord, this judgment, this Basti Kasim, your Lord, stated that driver is the best witness. It is the responsibility of the insurance company to bring the driver on the witness box. If driver does not come, then adverse inference is to be drawn. Like Mita Samanta, it's always the case of adverse inference. You do not prove your case. You always believe what is adverse inference. You come, my lord, you stand in the witness box, you say whatever you like, this, that, whatever. And then you say, no, I've come. Since insurance company is not bringing the driver, since insurance company is not bringing the owner, adverse inference is to be to be taken against the insurance company, and award is to be passed against the insurance company, because why they did not bring those persons. I always, this issue always troubles me, that when the claimant comes up before the court, assuming for a moment, insurance company does not appear, it's the next party. You prove your case.
Yes.
You don't prove your case. Your case is full of contradictions. You keep on changing your color. And then you say, insurance company did not do this. Insurance company will not do anything. You prove your case, you take your money. As per your own case, as per your own evidence, your entire case falls flat. You are not entitled to anything. Forget about what insurance company did, what insurance company did not. I'm showing, these contradictions to your lordship. So, this Basti Kasim again, goes back to the point that insurance company did not bring the owner. Owner, which owner? The owner who does not inform the insurance company, the owner who does not comply with the statutory provisions of the act, the owner who does not inform the police, the owner who does not take victim to the hospital. They say that you believe the testimony of that owner. Yes. And every single step I'm showing the lordship how he is breaking the law. So this was the judgment, and then again, at page number 5, Ravi versus Patinanan has again been shown. Page number 6, at the top, is done by Dinakar Rao versus ICICI. Here, FIR was initiated against the unknown vehicle. Vehicle was unknown, and subsequently, the vehicle was brought into the picture. So this was the another judgment which was shown to his lordship on behalf of the claimant. Now, how his lordship has dealt with, at page 6, the last paragraph, the third paragraph, starting with having heard. My lord has seen that, not having heard. But I'm on the findings now. Having heard the learned advocates for the respective parties, it's found that the insurance company has thrown challenge to the award solely on the ground of non-involvement of the offending vehicle. In order to appreciate the opposite issue, it would be profitable to refer to the written statement submitted by the insurance company. Insurance company, in its written statement filed in the proceeding, has categorically denied the allegation of involvement of the offending vehicle. I have shown to your lordship, not in my additional written statement also, I have denied. I will ask your lordship. In order to establish the involvement of the offending vehicle, the claimants had adduced the evidence of victim, PW1, and another witness, Shivaji Mondola's PW2, identical to our case, two witnesses. Victim himself, gave evidence. It was an injury case. Though the PW1, the victim of the alleged accident, stated in his affidavit that while returning home from Kamrapara to Kurul, the tractor being registration number so-and-so, going towards Kurul dashed him. Yet in his cross-examination, he stated that he became senseless as a result of the accident and could not see the number of the offending vehicle. Contradiction. Therefore, the evidence of victim, so far as the involvement of the tractor is concerned, becomes inconsequential. Turning to the evidence of sole eyewitness PW2, it's found that he stated in his evidence that the victim was dashed by tractor bearing registration number 0203. Both OPW1, that is the owner, and OPW2 is stated in their evidence in chief that the alleged vehicle was a commercial vehicle. However, the sole eyewitness stated in his cross-examination that the number of the offending vehicle was fitted, your lordship will kindly note, was fitted in a number plate in the rear portion of the offending vehicle, and it was written down in a white board with black ink. My lord knows, my lord, commercial vehicle in our country, my lord, they all are, my lord, with yellow number plate, with black ink. On private vehicles, my lord, white and black. The witness, the alleged eyewitness, my lord, again, my lord, this, my lord, howsoever, my lord, you try to plug in the loopholes, if, my lord, the cross is perfect, you are always caught. This eyewitness gentleman came up and he said, my lord, that it was a number with white color with blacking. It was a private vehicle. Whereas in actual, it was a commercial vehicle. Owner came and admitted it was a commercial vehicle. Policy was of a commercial vehicle. So by this, it was caught because he was very sure that it was a white number plate. Well, then his lordship has quoted Rule 52D of the Central Motor Vehicle Rules, which says that the registration number of a commercial vehicle should be with the yellow color, and the numbers should be written in the number of alphabets should be written in the blacking. Yes. I'm at page number 8. As per the, I'm not reading this section because section was very clear. Rules, Central Motor Vehicle Rules. But at page number 8, the paragraph starting as per the opposite rule. The commercial vehicle's number plate should be yellow with black color numerals. Therefore, the evidence of PW2 sole eyewitness that the number plate of the alleged vehicle was white with black ink raises a doubt with regard to the involvement of a tractor having a commercial registration, which is alleged to have been involved in the present case. The victim PW1 has stated in his cross-examination that the PW2 one Arup Hathi and his wife Purnima Maji witnessed the accident. Save and except PW2, claimant has not adduced the evidence either of his wife or Arup Hathi. It's not in dispute that there is delay in lodging the FIR of more than 300 days. In backdrop of the evidence discussed above, let me examine as to whether the delay is properly explained or whether such delay is fatal to the claim case. It's pertinent to note that the FIR has been initiated on the basis of an application filed before the learned CJM Bardhaman under section 156(3) of the CRPC on the ground of refusal by the police authority to accept the FIR. There is no iota of evidence that prior to filing of application under section 156(3), the complainant approached the police authority. The PW1 stated that his wife informed the police after the accident, after 3-4 days of the accident. Neither such fact has been stated in the petition under 156(3), nor any document or journal diary has been called for to establish the fact that the wife of the victim lodged complaint before the police alleging of the such accident. That apart, none of the eyewitnesses, namely Shivaji Mondal or Arup Hathi, informed of the accident to the police. More so, OPW1, owner of the offending vehicle, and OPW2, driver of the offending vehicle, who admitted that they knew about the accident, also did not inform the police of such accident. Your Lordship will see, 134 has been taken care of. It is their duty and responsibility that when an accident happens, they should inform police, they should inform insurance company, they should take the victim to the hospital. They did nothing. What they do? They say, yes, vehicle was. When 2 years, 3 years, 4 years, 5 years, 10 years after the accident, the easiest way, take money from the other side, come to the witness box and give a declaration, yes, vehicle was involved. You kill somebody, you do not have that moral responsibility to take him to the hospital. You take money from insurance company because of indemnification, what insurance company provides. You come before the court and say, yes, I am entitled for indemnification. I killed somebody, indemnify. Why? Because I have taken the insurance policy. And what about the terms and conditions? This is what his lordship has taken care of, because he did not even inform the police authorities about the accident. Yes. The same, what has happened with us. If this 7214 was involved and it killed somebody, what did the owner do for this 1 month? So, continuing from there, more so, the OPW1 owner of the offending and the OPW2 driver of the offending vehicle, who admitted that they knew about the accident, also did not inform the police. It is curious to note that none of the witnesses who had knowledge of the accident informed the police of such accident, which raises a doubt. There is no plausible reason coming up as to why these witnesses failed to inform the police if such occurrence actually has taken place. Mr. So-and-so, learned advocate for the respondent, claimant, referring to the report of the Honorable Supreme Court in Ravi, tried to impress upon the court that the delay in lodging FIR is not fatal to the claim. Honorable Supreme Court in the aforesaid report has observed that in case of delay, the courts are required to examine the evidence with a closer scrutiny. And in doing so, the contents of the FIR should also be scrutinized more carefully. If court finds that there is no indication of fabrication, or it has not been concocted or engineered to implicate innocent persons, then even if there is delay in lodging the FIR, the claim case cannot be dismissed merely on that ground. These are the conditions in Ravi versus Badrinath. Everything has to be looked into. The court has to be satisfied. All other things are in place. Then, this delay can be controlled. Second para, bearing in mind the opposite proposition, Upon scrutiny of the evidence of the witnesses, as discussed above, it's already found that none of the witnesses to occurrence or the victim or the owner of the or the driver informed the accident to the police. The FIR has come to existence after an inordinate delay of more than 300 days. Though it has been stated that due to injury, the complaint could not be made, but it is found that the injured had been discharged on 15th March 12, whereas the complaint was filed in the court on 21st January 13 under section 156(3) of the code. More so, the fact of accident, though stated to have been intimated to the police by the wife of the victim, has not been supported by any document. The medical documents on the record do not speak of any road traffic accident. So far as the decision of the Honorable Supreme Court in the case of Janavai Supra, it's found that same is distinguishable in facts and thus does not apply to the facts of present case. Therefore, bearing in mind the evidence of witnesses discussed above, the witnesses not informing the police about plausible reasons together with unexplained inordinate delay in lodging FIR, the involvement of vehicle in the accident becomes doubtful and is very much fatal to the claim of the claimant. I find substance in the submission of Mr. So-and-so, relying upon Anil and Kalpana with us. In view of the above discussion, the appeal stands allowed. Judgment and award of tribunal is set aside. Apparent insurance company liberty to withdraw the statutory amount and the balance amount from Honorable High Court along with the interest. Appeal disposed of. Interim order stands vacated. Millard, what I was trying to impress upon your lordship, the honorable courts, are looking into every single aspect. Because when the claim is they come before your lordship, they come to the court below and they ask for the money. It is not you punish somebody for his misdeeds. When you ask for the money, you should come with clean hands. This is the first and foremost. You should come with the clean hands, because the person, who is found to be fraudulent, or who does not come with the clean hands, is liable to be thrown out at any stage of the proceeding.
Yes.
Whether in the tribunal or in the High Court or before the Honorable Supreme Court, at any stage, if it is found that no, he's playing dirty, his case is to be thrown out. Here I have been able to show to your lordship, the glaring discrepancy, what they are doing. First of all, the FIR says A. One after that, from nowhere they come up with B. I have specific, written statement, is specific there that A belonged to a police personnel. It was uninsured. And this B was subsequently brought by that gentleman. B is my vehicle. It has been implanted. The owner of the B does not say anything. He is sitting tight at his home. Yes. Subsequently, he comes up and says that yes, two eyewitnesses. One says red color, which is it's a blue color, and the other says it's a Hero Honda. It is it's a Bajaj. This is a Bajaj M80. By any stretch of imagination, these two cannot be brought at the same platform. Black and blue, I understand. That well, maybe some percentage of color blindness is there, or maybe if one looks at the distance of 15 meters, 20 meters, maybe that chance can be given. That also normal, not normal blue. But one is he says, I'm sure about it. So these two cannot come on the similar platform. And lastly, on the last day when I was making submissions, in one of the cases, I had indicated to your lordship, this magnitude of fraud. On the I was not, because orally I submitted to your lordship. I was not supported with the documents. I'll just show it to your lordship. My lord will only keep this. I am not saying that this specifically relates to this case, but the fraud where it has gone, my lord will only keep this in mind while deciding. Your lordship will kindly have a look at this, the Supreme Court. It's a figure. This your lordship will kindly come to. The starts with May I just read,
Yes.
It starts, despite our strong observations against the Bar Council of UP, in our earlier order dated so and so, nobody has appeared on behalf of Bar Council of UP. Last time, para 2, we recorded the statement of Sri so and so, learned counsel who represented the Bar Council of UP, that he is not receiving any further instructions from the Bar Council. We observe that it is very unfortunate that in such a serious matter, where the allegations are of filing of fake claim petitions in which the advocates are also alleged to have been involved. Your Lordship, kindly take note. The Bar Council of UP is not giving instructions to their advocates, and it shows the callousness and insensitiveness on the part of the Bar Council. Therefore, we requested Mr. Manan Mishra, Your Lordship knows, he is the chairman of the Bar Council of India, the learned senior counsel and the chairman of the Bar Council, to look into the same. There are three. Today also there is no representation on behalf of the Bar Council. Filing of fake claim petition is a very serious matter. It ultimately affects the credibility of the institution as a whole. Legal profession is always considered to be a very noble profession, and such things of filing fake claim petitions in the courts cannot be tolerated. It's the duty of the Bar Council of the state and the Bar Council of India to maintain the dignity and restore the glory of the legal profession. In the present case, unfortunately, the Bar Council of UP is not at all serious and has observed herein about insensitive. Under the circumstances, we have no other alternative but to direct the chairman and the secretary of the Bar Council of UP to remain present before this court on the next date of hearing to assist the court. Para 4. A status report on affidavit has been filed by SIT. A special investigation team was formed in terms of the direction of the Honorable Supreme Court, only for the state of UP. I personally, I have filed 2 writ applications before this Honorable Court. Affidavits are completed for formation of SIT. It is unfortunate on my part that I could not get those matters heard. The state appeared in both the cases. The state filed their affidavit in opposition. The state is not favoring for this formation of SIT. The state is saying in their affidavit, which is still pending, both these cases, post-writ application, they do not have the infrastructure, they do not have the personnel, they do not have the money. So this SIT, this is what they are opposing. The matter is pending, still. In the reference of this SIT, I just pointed out to your Lordship what is in Calcutta position. A status report on the affidavit has been filed by the SIT. It's reported that out of the 92 criminal cases in various districts registered till date, of which 28 advocates have been named as accused persons in 55 cases. The investigation has been completed in 32 cases, and charge sheet has been filed. In rest of the cases, the investigation is stated to be pending. It is stated that consequent to the direction passed by the High Court of Allahabad, Lucknow bench, Lucknow to the Special Investigating Team UP, Lucknow, for investigation of the cases of suspicious claims, total 233 suspicious claims of various insurance companies have been dismissed or dismissed in default or not pressed to, of which various claim petitions claiming amount of rupees. This was the figure. Your Lordship will kindly take note of this figure. 300 crores. Yes. Claim cases worth 300 crores were not pressed after the formation of SIT. This is what the magnitude on the last date I was referring to, your Lordship. One state have been rejected 300 crores and then 76 lakhs 40,000 have been rejected by the tribunals. It is very unfortunate that despite the fact that the FIRs have been filed as far as back in 2016-17, still the investigation is reported to be pending. Even in the cases where charge sheets have been filed, no charge has been framed by the courts below. The SIT was constituted by the High Court to look into the filing of the fake claim petitions, and with the specific purposes, still the investigation in most of the cases is reported to be pending. We deprecate the negligence and all the lethargy on the part of the SIT in not concluding an investigation even after 4 or 5 years and of the FIR. Further directions given down below. This I read and I showed to your Lordship, just to point out where we are. And it is not confined to UP. This order is confining to UP. This is happening everywhere, the whole of country. And your Lordship will see the amount involved. What are we doing? Whose money? Where is it going? How is it going? Who is involved? And this is why, in the context of this, if Lordship sees how the cases are being made up, then your Lordship will kindly take note of this, appreciate the arguments which are being made, and in view of these glaring discrepancies in evidence, this red, blue, black, MAT, Hero Honda, these are, when not covered up by any means, this cannot be brought on the same platform. This should not be allowed. Lordship will kindly dismiss this. Yes. I'm grateful to your Lordship. These are my submissions. I'm
Yes. For the claim and response. Time for the claim. My lord, just starting my arguments, my lord. I shall, my lord. Though it need not, because my learned friend has already submitted his actual matrix of the my lord, what wrong my lord statements while he was arguing the actual matrix, my lord, I would, my lord, draw your lordship attention and power. My lord, the accident took place on 1st February 2003 at about 9 p.m. at night. My lord, on a Igra road. And on 11:30 p.m. on the same day, kindly note it. Yes. On the same date, 1st February 2003 at 11:30, complaint was given to the the concerned police station. Yes. After half an hour, the next date starts. So the case was started on 1st February. Accident took place on on 9/11/30. Complaint was filed, and next day, 2nd March 2003, case was started. So my case is not in delay in lodging FIR. On the same date, on the same date of accident, the complaint was lodged. But the police has received the complaint on 11:30 and started the case just half an hour next day. This was shown in the contents of the FIR. I shall place. Yes. Inter-submission of my learned friend is that it is a case of delay in lodging FIR. So, secondly, it is a case of implantations of a vehicle, alleged accident. And thirdly, though FIR was lodged, on on the date of accident, in the contents of the FIR, the number of the vehicle has been changed in the seizure list and in the charge. So there is some fraud and some the new things have come to claim the compensation. Yes. My learned friend has relied 4 judgments. That is first Hon'ble, where the Honorable Apex Courts says that High Court has pointed out many discrepancies. Postmortem report was not there. There is different versions. Everything there are some discriminations. In our case, there is no discriminations. Only what my learned friend says, the number of the vehicles is in the FIR, and number of the vehicle in the seizure list and chassis is different. And secondly, but not is to the color of the vehicles. The red color or the black color. Your lordship, kindly visualize at night, a person who saw the accidents. At night there is no light. Presumption is whether red color or black color. Even if the FIR maker was not examined. No, FIR maker was the another person, and my lord, the evidence of the two eyewitnesses. One of the eyewitnesses was examined by the investigating officers. Now, my learned case is entirely on the basis of the additional statement. In the my lord, evidence in the written statement, there is no specific denial that the implantations of the vehicles, there is two numbers. But in the additional written statement, my lord, on the basis of the my lord, the report of their my lord own investigator, additional written statement was filed. And it appears from the additional written statement, my lord, the insurance companies, my lord, averted that the my lord, the FIR makers on 21st, he my lord said, if your lordship say, lordship kindly turn to my lord, the additional written statement, that is my lord, page 8. My lord, before the learned my lord magistrate, the de facto complainant, who was the FIR maker, my lord admitted that what I mentioned, the my lord, the vehicle was not the real my lord, the number of the vehicle. The vehicle number is so and so. And on that basis, my lord, the police has investigated and police, my lord, seized the vehicle. As my lord, police after investigations has filed the charge sheet. My lord, there is a my lord, the evidence, both oral and documented evidence on the part of the claimants. My lord, the two eyewitnesses, my lord, though my lord, claimants number one, the widow, my lord, she did not see. Even if my lord, in her my lord, affidavit, number of the vehicles rightly mentioned. In the my lord, claim application, the number of the vehicle is rightly mentioned. In the my lord, evidence of two eyewitnesses, the number of the my lord, right vehicle was rightly my lord said. My lord, on the contrary, my lord, there is no evidence. No, my lord, contradictory evidence, only filing additional written statements on the basis of investigator. The insurance company, my lord, came to this honorable court challenging the award that this is a implantation of the vehicle. This is a my lord, the FIR was my lord lodged and my lord charge sheet was filed. There is a my lord, another vehicle, two vehicles. This is the my lord, the grounds by which can be entertained, my lord, may I prove by this honorable court, where our high court says, even if my lord, I have brought the my lord reported decision, the division bench of our high court, the honorable Justice Dipankar Datta, where my lord, the two things my lord were raised by the insurance company, that the additional written statement in the FIR, my lord, the vehicle number is one, and in the charge sheet, the FIR number is different. And on the basis of the my lord, the investigator, the insurance company has filed the my lord, the written statements. Now, my lord, our division bench, my lord, dealt to it that no report of the investigator has been filed, even if investigator has been summoned to prove. In our case also, the insurance company had not filed the investigator report on the basis of the it's Mongara. On the basis of investigator report, the additional written statement was filed. Our High Court division bench says, even if there is a discrimination, in the FIR and the charge sheet on the basis of investigator report, investigators ought to have come, ought to have been summoned. Even if investigator report ought to be filed, otherwise insurance company has no defense. Our instant case, is only filing written statement on the basis of the investigate. Kindly note it. My lord, I will place the judgment in support of my case.
Yes.
My lord, my case is not the delay in lodging FIR. But my lord, on this same date of accident, FIR was lodged. Subsequent date, the case was started. My learned friend has repeatedly said, after my lord 1 month, after my lord 21 days.
No, that is not the issue here.
Yes, not. I put a question myself, my lord, what the insurance company had discharged. My lord, our High Court says Mita Sabuntus. And following that decisions, my lord, our High Court's my lord, the division bench Dipankar Datta also says, I have bought the my lord. If the my lord, Mita Sabuntu's case, what is my lord, your lordship is aware, where the owner has not contested, where the insurance company has obtained a leave under section 170, having a right to defend in all points. Where the question has been propped up by the insurance company ought to have summoned the driver who has explained that he was not driving the vehicle on that date of accident. Where the owner, my lord, has to be summoned, where owner can say that my vehicle was not involved. My lord, if that two things, my lord, if the driver or owner have not been summoned after taking leave under section 170, my lord, the adverse inference can be drawn that on the same date of accident, the offending vehicle was involved, and there was a rash and negligence driving of the offending vehicle of the my lord, the vehicle who caused the my lord, the motor accident. Now, my lord, Mita Sabuntu has been followed. In subsequent, my lord, our division bench in many occasions, I have also brought the judgment. My learned friend has referred, my lord, the Hon'ble, my lord, the Supreme Court judgments, where my lord, the tribunal awarded High Court on different my lord, discrimination point, where postmortem was not there, where my lord, different versions the my lord, relating to the happening of the accident. But my lord, our case is very clear. Only my lord, this wrong number in the FIR is my lord is vitiated the entire claim of compensation which was granted under the beneficial social welfare legislation. I have also 5 decisions, my lord, of my lord deferred High Court. What is the values of FIR? What is the contents of FIR? Whether it is a substantive evidence or it is a corroborative evidence. Punjab High Court, Tamil Nadu High Court, Allahabad High Court, Uttar Pradesh High Court. Different High Court says, FIR, my lord, that my lord, tribunal also followed one, my lord, the Punjab Haryana High Court, that the FIR was, my lord, lodged or written in a hasty way. It has not been, my lord, affirmed or solemnized before any authority. It was the declarations. Now, my lord, the evidence, my lord, is much more, my lord, powerful because it has been taken, my lord, on oath before the court.
Yes.
My lord, the chart, what number of the, my lord, the vehicle was written in the chart sheet, that was adduced by the, my lord, the time, by the, my lord, claimants. And cross-examination, my lord, is a red color or, my lord, black color. Now, my lord, I shall argue, my lord, on 2-3 corners. First, this is not a case of delayed lodging of FIR. This is not a case that my claim case should be, my lord, thrown out or the claimant ballot should be deprived in getting compensation on the wrong mentioning number of the offending individual in the FIR. Thirdly, my lord, that there is no scope for my lord, the tribunals or my lord, can intervene that this is a case of implementations of the PQ. There are 3 points and also the assessment which the tribunal has followed. I give it to your lordship that whether it is just or not, I leave it to your lordship.
Yes.
Now, my lord, first, my lord, I will place that what is the, my lord, the FIRs, what is the value of FIR? Because my landed friend time and again says the FIR, the one number of the vehicle was mentioned and in the serial list and is, so it is a case of implementation. All are correlated. So I will first, my lord, strike, I will first hit the what is the value of contents of FIR.
Punjab, Haryana, who's Punjab, Haryana?
Yes.
This is a decision where the tribunal also declined. I am also declined. That Sama versus Hon'ble and others, which are given by the Punjab Haryana High Court. Now, my lord, your lordship kindly turn to paragraph 7. It was reported in my lord on the head, my lord, 1994, volume 2, ACC 357, equal to 1994 ACJ 432. Now, my lord, paragraph 7, the other ground taken by the tribunal for not awarding compensation is that in the police report, negligence has not been attributed to auto rickshaw driver. I am not inclined to subscribe the view taken by the tribunal as in accident case. FIR is often lodged in a hasty and the same cannot be a substitute for the evidence giving exhaustive version of the occurrence. The statements before the tribunal are made on solemn affirmation, where the FIR is never lodged on solemn affirmations. This is short judgments, my lord. What is the value of the FIR? The FIR is lodged in a hasty way, but the evidence which was made before it was not made before the, my lord, the on a oath commissions, but the evidence of the, my lord, the oath commissioner is much more powerful. So FIR is or cannot be substantive evidence, my lord, in a motor accident case. This is my first judgment. My lord, second judgment is, I shall, my lord, is a Andhra Pradesh judgment. Contents of FIR not admissible in evidence. এটা হচ্ছে ইউনাইটেড নেশনস কোম্পানি আছে পারপুদি না সেকেন্ড হচ্ছে এটা সরি ন্যাশনাল বিষয় কে ইদমা 2005 ভলিউম 2 BSc 956. The contents of Malan FIR not admissible in evidence. Now, this is a long judgment. I shall read out the relevant portion. Your lordship kindly turn to page 5 of that the judgment page, paragraph 29, 30 onwards. May I permit it to be? The wife of the business was examined as AW1 on behalf of the applicants. The past information report was marked as exhibit Although AW1 she stated that the FIR which was reviewed by some other third person, it was mentioned that the disease was in intoxicated condition and because of the small accident to the victim of the disease stopped his vehicle and thereafter when he was crossing the road on foot to inform his owner about the said accident and unknown vehicle which was running a high speed hit him and the resulting of his intoxication death. The person who gave the FIR conspiracy was not examined. The non-examinations of the person who gave the FIR, in my considered view, renders the contents of the FIR inadmissible in as much as the same were not spoken to by the person who lost the FIR. Now, my lord, next page is paragraph 31. It is to be further noted that the contents of the FIR need not necessarily be always only the object of lodging FIR in ordinary course would be only to the limited extent of legal law in motion. The contents of FIR must be proof examining the person who lost the same and shall always be subject to decisions in the competent court. Not even subscribed the FIR was examined. Therefore, AWR, who is the wife of the deceased, cannot be said to be the competent person to testify the contents of the FIR as far as this type of the FIR was not examined. The evidence of AWR, wife of the deceased, cannot be something that was objected, but as already stated, the veracity of the contents of the FIR was not found. So, my lord, this my lord, two things says that unless the author of the FIR was examined, my lord, the contents of FIR was not admissible in evidence. My lord, in our case, FIR was lodged by my lord
One Sahu.
South. That was the brother of the deceased. Now, my lord, he was not, my lord, examined. So his version cannot be, my lord, contents in the FIR is not, my lord, admissible, my lord, in this criminal, not criminal case, in this case. Although, my lord, as per the investigation report, my lord, the insurance company says the de facto complainant, that is the complaint lodged on the basis of the statement of the de facto complainant before the learned, my lord, judicial magistrate. My lord, the accident was happened on, my lord, caused by the vehicle number so and not by the vehicle which was mentioned in the FIR.
Where it is mentioned? Where it is mentioned, you have submitted.
Yes, my lord, your lordship, kindly see the additional written statement of the, my lord, the insurance company. My lord, paragraph 2. My lord, page 8. Got it? My lord, paragraph 2.
Yes.
My lord, that your opposite party investigated the matter regarding the alleged accident and found as follows. Shri Narayan Chandra Shao, son of so lodged FIR on 1st February 2003 and the same was started in Extra PS so. In this written complaint, a motorcycle bearing number 4582 was mentioned as offending vehicle. Furthermore, after proper searching, it is crystal clear that at the time and date of this alleged accident, the said motorcycle had no insurance policy from your concern. And after knowing it, if the de facto complainant made a statement before learned judicial magistrate third court at Contai or Ekushan, the conspiracy between the owner of the said motorcycle and the registration number of the vehicle also doubtful. My lord, where the my lord, so my lord, on the basis of the my lord, the statements, my lord declared before the learned judicial magistrate, my lord, though my lord, the police forwarding report or anything from the police, that on the basis of the statements, subsequent statements, my lord, made by the de facto complainant.
It was not made here.
My lord,
The
that
subsequent
the
statement.
investigator report, on the basis of the investigator report, the insurance company has filed the written statement. That was admitted. That was stated, my lord, in the additional written statement, that the de facto complainant made a statement before the learned judicial magistrate, third court at the contact, that on 21st February 2000, the conspiracy so and so. And my C, paragraph C, that the that the ultimate result of the said conspiracy with another motorcycle entered into the case bearing number so and so, and the owner of the said vehicle is a relative of the owner of the aforesaid vehicle so and so, and the owner of the motorcycle bearing number is a police personnel. So, my lord, the number, what is changed, my lord? My lord, the de facto complainant, though he was not examined, he, my lord, declares, my lord, subsequently before the, my lord, the police stations, that what I am, my lord, supplementary, my lord, the complaint or anything, whatever you lordship accept, that on the basis of the statement made by the de facto complainant, and also it was forwarded to the judicial magistrate, the, my lord, the insurance company said that there is a conspiracy. But it was come out not, my lord, on imaginary basis. It was based on the, my lord, the declaration statement by the de facto complainant on 21st, my lord.
No, if you are going to support the paragraph B of the written statement, additional written statement, that it goes
Paragraph?
against you.
Paragraph C.
Paragraph B, what you have written, what you have already.
I am only pointing out, I am only drawing your lordship attention that on the basis of the declaration by the de facto complainant.
Yes, the sentence is not there. Sentence is regarding conspiracy.
A conspiracy. But, my lord, the insurance company stand is a conspiracy.
Yes.
But the
This is
things
their
come.
stand.
Yes, my lord, that one. But, my lord, on the root of that, my lord, the conspiracies, my lord, started from the subsequent, my lord.
Look, there are two statements can be taken.
My lord,
There are
magistrate
a
accepted
statement. There
and
are a statement.
further directed the investigator, to investigate the matter. And on 21st, my lord, the police has seized the vehicle. And subsequently, after in the March, just after few days, one charge sheet was filed. It was not a case
There
of
are
conspiracy.
two ways. There are only two ways. The statement of de facto complainant can be taken by the magistrate, by the court as a witness, or by statement recorded under section 164.
164. My lord, I shall only touching that the subsequent.
If you support this paragraph,
No,
it is,
not support, my lord,
then
that not, I have not
it is going
supported.
against you. They have made that there is a conspiracy.
I am
between you.
against the, my lord, the written statements on that content, on the basis of investigator report. The report has not submitted, the investigator has not been called for, has not been summoned. For that, my lord, what happened? Our High Court says, no. The one vehicle mentioned in the, my lord, FIR, and another.
Yes, you show me the judgment.
Yes. My lord, the FIRs, my lord, there are other 2 or 3 judgments, just I am handing over. পরেরটা দিয়েছে অন্ধ্রপ্রদেশ হাইকোর্ট পাড়াপুর মানে 5 judgments are Your lordship, kindly, I shall read paragraph 4 of that judgment. It's a Allahabad High Court judgment. In so far as Exhibit B1 and A4 copy of FIR is concerned, the same is registered and information given by so and so. It reveals that on both driving the second episode, so and so. Now, my lord, second line, the contents thereof were not proved by examining the person who recorded the FIR or the inspector of the police who investigated the offence. The FIR also contains the statement given by the exponent hearing who is the author of this and so and so, so and so. He only gave opinion to the regard of the FIR. So and so. In the absence of any proof of this statement made in FIR cannot be accepted. So, if the FIR maker was not examined, so the contents of FIR cannot be exhaustive and cannot be accepted.
Then your case goes.
Follow what my learned friend assailing the number of the vehicle. In fact, other contents is my lord, other contents is my relevant.
This is the judgment goes against you. If the FIR maker or the investigating agency or
My lord, I shall not rely.
or the FIR who recorded the FIR not produced.
I
No, it was written like that.
Yes, my lord.
FIR also consistently given by the
Lord,
and uncle that is
the admissibility of FIR.
Intoxicated condition in the absence of a proof in statement by FIR.
Well, you lordship is seeing the Allahabad High Court judgment. Yes, my lord, এটাতে তো করে বিরাট সিং and মধ্যবর্তী।
Give me the judgment where the number were different in FIR and the charge sheet. So, but
No,
the charge sheet
Mala-
has been accepted by the court to give the compensation.
Yes, my lord, that's my lord, the
Give me that judgment. I want to see that judgment.
my lord, one judgment that the contents of FIR, if FIR was my lord made in a hasty way, that cannot bind the claimants to deprive the compensation. That my lord, not
That is not necessary. That is not necessary. FIR is not the only the corroborative value is
My
there
lord, that
in
judgment
claim
will not-
application. It is not a substantive piece of evidence. Everything is there. You show me the judgment.
Yes, my lord, the judgment, my lord, the delivered by His Lordship, the Honorable Justice Dipankar Datta, WBLR, নাম হচ্ছে ন্যাশনাল ইন্স্যুরেন্স কোম্পানি ভার্সেস রানু সিং এন্ড আদার্স। Judgment, my lord. My lord, the award was passed, challenging that award. My lord, insurance company preferred this appeal
Yes.
on the ground that the FIR, my lord, the name of the vehicle is one, and the charge sheet is, my lord, the vehicle number is different. Now, my lord, your lordship kindly turn to first paragraph, last line.
Yes.
My lord, here the vehicle number is mentioned in the FIR is SK033843. Your lordship got it. Consequently, FIR was lodged mentioning the pickup van bearing registration number SK033843 as the offending vehicle. However, investigation conducted by the police revealed that it was the vehicle bearing number is WB33 /0188. That was involved in the accident resulting in the death of the vehicle and not the other pickup van bearing number so and so.
Yes.
Now, my lord, your lordship kindly turn, my lord, is not your lordship kindly turn to the my lord, page 4. My lord, here charge sheet was filed. FIR, my lord, the number is SK03, but in the charge sheet WB33. Page 4 top. My lord, the additional here also additional statement was filed on the basis of investigator. That apart, we find from the records that the insurer had filed an additional written statement. In such additional written statement, it was pleaded that private investigation had been conducted by one Suruti Trust in order to in orders of the insurer. Report submitted by Siddhas revealed that the accident was caused by the vehicle bearing number so and so, but by the vehicle bearing registration number S2. In course of trial before the tribunal, the insurer did neither produce Siddhas as a defense witness nor his report produced. So ultimately, my lord, the award passed to the tribunal. My lord, what the insurance company has challenged has no interference, and it was affirmed. And my lord, on the basis of what some amount of compensation was, my lord,
Very well.
it is my lord pat on the judgment on my case. That investigator report, the additional witness statement was filed. Hearing concluded.
Please take down. Hearing concluded.
My lord, your lordship has been satisfied with the judgment.
No, I am not satisfied.
Not satisfied, but my lord, I have some judgments. My
Let
lord.
me pass the order.
Oh, yes.
You just hear it.
My lord, from 2, my lord, your lordship will not be taking motor accident matter.
No, from 2 I will take the matter.
Only
All the matter.
this appears from Thursday onwards.
Only
Thursday or Friday.
Thursday. Only Thursday. Yes, I'll take. I'll take. Argument on behalf of the insurance company appellant as well as the claimant respondent concluded. During the course of argument, it appears to me that the vehicle number was mentioned in the FIR otherwise than it appeared in the charge sheet. The IO has not deposed in this case. Before the learned tribunal, and the report submitted by the final report submitted by the investigating agency within bracket police under section 170 CRPC is very cryptic, considering the same. For the bed stop here, considering the same, for better determination of this matter, the CD of Agrappius case number 10 of 2003 dated 2nd February 2003 is required to be looked at. According to next paragraph, the SP Purvo Mendipur is directed to do the needful for production of the CD before this court within a fortnight.
And the register general,
The Registrar General, next part, the Registrar General is directed to make necessary arrangement so that the SP may be so directed to produce the CD of the above mentioned case, a number 13.
within rather short date.
Serious date of number board. Agra PS case number 10 of 2003 dated 2nd February 2003 under section 279 427 304 so that the estimate is directed for the CD of the case number such the other mentioned case within a fortnight. This is the matter further for hearing on Fourth of July. Short
Date matter is
4th of July. I will have the
Panchayat election.
what is the Panchayat election?
I have get to that special messenger will not be submitted by my learned friend.
What necessary? Registrar General is directed. So special messenger not necessary. If they shall not appear, then the necessary direction will be first.
So your lordship will decide to take up the matter on fourth.
Yes, on fourth again. It will be listed. Right. Right. The rest matter at 2 p.m. All are released.
Seven.
Yes, item number 7.
Yes.
You are
I mean, respond one.
respond.
It's a company.
Who is appearing for the insurance company?
Last date I some copy. I know the some copy. EM report policy memo I think I give. I informed her. Madam. I did not again.
You just sit. I am calling first time. I will call on second time.
Yes, sir.
Otherwise, you can inform him. You can inform her that the matter has taken up.
Yes, madam.
Next.
Yeah.
18, you are the appellant.
Yes, madam.
And who is for the respondent?
Mr. Pahari Diyar. This case has already disposal. Or some clerical mistake is there. Can 1 and 2. Can 2 and 3.
Give me the papers.
Can 2 and 3. Can 2 and 3.
Where is can 3?
Yes.
Can 2 and can 3.
2 and 3. Yes.
Yes, can 3, can 2. Yes, both the cans are there.
Yes.
Both the cans are. I found it.
Can 2. Well, April number 4 is that. So her name is.
So can 2 for
Corresponds the April number 4. Ferrer and Eagles.
Khelarani Ghosh.
Yes.
Khelarani Ghosh died.
Yes.
Final order has been passed in this matter.
Judgment already delivered.
Judgment delivered.
Yes.
Where is the judgment? Judgment with this record.
Honorable Justice Rajsakar Mahanta.
Shekhar Besara.
That judgment at 27/8/2021.
Okay, I have got it.
On that judgment, the learned court error, special court additional district of Dukapur is not. It will be 5th additional district of Bardhaman. And MSC case number, which are mentioned 62 of 2011, public 50 of 2009, it is not correct. It will be next date order, next order 15/6/2022. 15/6/2022. The MSC case number is correct, but code number not mentioned. Same as here. Tribunal Court 5th Additional District of Bardhaman. It was mentioned the special term Additional District of Bardhaman. So I can 3 I have already mentioned.
So this is for can 3.
Can 2 expand the petition of the can 3 three amendments is there. One amendment is the MSC Tribunal Court will be 5th Additional District of Bardhaman, not Durgapur Special Court. Can the exponent appellant number 2 and 3 para 5, 4 and 6. Can 3, 4, 5, 6. 4 is the MSC case number 26/96/2006 151/28. Claimant number 1 appear on the number 3 as wrongly Champa Ghosh, which CHAM, not N. I have filed all documents, Aadhaar card, bank passbook, and voter card.
So name of the appellant number 1 would be Champa Ghosh.
Champa.
CHAMPA,
Yes,
not
not
N
N.
NP.
I have submitted the documents in your Aadhaar card, bank passbook, PAN card, and voter card. All documents are submitted. The error might be one is not already, one is felony, also will be detected.
No.
Second,
Come on. The number 1.
number 1 Champa,
What is the name? CHAMPA.
CHAN, not N.
What is correct? N or M?
M. Yes, yes.
M is correct.
Yes, madam. I submitted so many documents there.
No, no, no.
Ah,
What you propose, M is correct.
Yes, yes, madam.
N is not correct.
Not correct.
But your claim application stated you are N.
N. But
You made affidavit before the learned tribunal N. You signed as N.
in written Bengali, my lordship, Champa. Written in Bengali, Champa. Sign in Bengali, my lord.
Not Champa, Chapa.
Chapa.
A CHNPA. Not Champa. Chapa.
But so many documents recorded in my Aadhaar card, PAN, voter card, PAN card, and other. Also,
She deposed before the learned tribunal as PW1 as Chanpa Ghosh,
Champa.
and he signed his English spelling as Champa Ghosh, not CHAM but AN. This is the difficulty here. That's why I'm looking so meticulously.
N and M. This is the difference between the N and M.
But he signed her name as N, not M.
M. Now we M. So documents are typed. Voter card, PAN card, Aadhaar card, and PAN.
How can it be allowed? After a long period,
This is the character mistake. Not in. How does it?
the issue is name of the appellant. It is in Bengali Chapa Ghosh. And appellant proposed it would be CHAMPA. But see MPA. N or M? This is the question. See, they propose it would be CHAMPA, as some documents are prepared like that. But she deposed before the tribunal as CHANPA,
Yes, madam.
and he signed as CHANPA. AN, not M, as PW1. How can it be allowed at this stage? Page number 6 of the paper book.
Yes. I'll take you, madam.
Bengali name appears to be different. Not Champa, but Chapa. In voter ID card, Champa. Whether she is a different person or not. Same person, identical person.
Yes.
So much error is there.
I not, the check cannot be cashed in time. The name is not.
Very well.
This is that. Calculate.
Mr. Pahadi, what can be done? So much error since the tribunal, order of tribunal, record
Yes,
of
yes,
tribunal.
I also agree, my lord. Full agree. But difficulty is the
Very well. And what is the other matters?
one is the major minor, appeal number. Now major, at the time of filing minor, she has major.
Appellant number 3
Three,
became
So it was-
major.
Shoikat Ghosh. I having the voter card, other card.
Became major during the pendency of the instant appeal.
Yes, yes.
So necessary noting is required.
I filed the call.
Necessary noting is required. This is for can 3
Yes,
and can 2.
can do already major. So on,
Can 2 already disposed of.
the major.
No. What is for can 2?
You know, can do already, claimant number 4, Kalarani Ghosh will be expanded.
Name of claimant. Who is Kalarani Ghosh?
Is the mother of the deceased.
Mother of the deceased. Is there any other heirs?
No, no. I mentioned the claimant. Only the applicant are the claimant. Claimant to I mentioned. 4. Claimant of
Whether you have filed any application for change the name of the court? No.
I filed the application, your lordship. The can see para 3, your lordship. Can see para 3.
Para 3.
And can do. Can do code number. Already mentioned. Para 3. Can see para 3.
Can 3 para 2.
Yes, your lordship. Will be moderated claim tribunal fifth court part 1 investigation number 96 of 2006 public 151 of 2006.
The case number is also erroneous.
Case number already rectified. The second order.
Case number rectified.
Yes. Order.
Yes, case number rectified.
But court number not rectified.
Court number. Okay. Please take down. Can 2 of 22 and can 3 of 22. Both the can applications were straightforward after passing of the final order of this appeal for some minor corrections. Stop. By virtue of Can 2 of 2022, Planet Advocate for the applicant submitted the applicant number 4, Khelarani Ghosh, died during the COVID pandemic on 26/9/2020. So, student 20 leaving behind no legal heirs except the present applicant. So, it did for necessary noting in the cause title of the name of the applicant. Let the name of applicant number 4, Khelarani Ghosh, be deleted from the cause title of the name of the master. And 3 of 2020 filed for change the name of the tribunal to be additional district judge at Durgapur to be motor accident claims tribunal 5th court bar 1 instead of special judge come additional district judge at Durgapur bar 1. Stop. It appears that the name of the tribunal was erroneously recorded. Was inadvertently recorded, not erroneous. Inadvertently recorded in the order passed by this court on 27/8/2020. Let the same corrected according to this order. Stop. Learned advocate for the appellant further argued that the name of the appellant number 1 was wrongly typed as CHAMPA Ghosh, Champa Ghosh, CHAMPA GHOSH instead of CHAMPA GHOSH. Stop. In support of his submission, he produced the Xerox copy of Aadhaar card, voter card, along with the bank passbook of the above mentioned passbook standing in the name of the appellant number 1. I am convinced about the submission of the learned advocate for the appellant regarding the name of the appellant. Thus, the name of the appellant number 1 should in the entire proceeding should be read as CHAMPA Ghosh instead of CHAMPA Ghosh. Stop. The department. Next one. The department is directed to took out the correction as mentioned above in the memo of the appeal within a fortnight. According to the can 2 and can 2 of 20 and 2 of 20 discussion.
My lord, responding appeal number 3 was the major, my lord.
Okay.
Appeal number 3, my lord. Can 3. Can 3, can 3. Can 3 para 6.
After appears measure appealant number
3.
3. We can measure the dependency of the appeal. So measure it. Call next item.
Item 99 of the appeal. Thing is, on the last occasion, my lord was pleased to direct me to inform the learned advocate for the respondent. Unfortunately, I could not. And Mr. Mahato, I believe, is off tomorrow, so he'll be more busy, I believe. So it would be better that I could not contact because no number was there. Better that if directly the respondents are contacted, either through an administrative notice or if my lord directs me, I can.
Please give me the papers. Please take down. The appellant is represented by Mr. SUBHENDU, learned advocate. Learned advocate for the appellant submitted that he could not contact the learned advocate at the respondent. Accordingly, the appellant is directed to serve a notice, serve an intimation regarding the listing of this matter to the respondent, informing them that the matter if the insurance company is directed, it is not possible.
Then once again, if they don't receive, then another step would be for administrative notice. Directly, my lord.
No,
Just the
only to intimation regarding the matter is to the directly to the respondent. Claimants. That the matter shall appear in the list on 6th of July.
Well, this is Purulia, so it will take a little bit of time. 6th of July is.
To file an affidavit of service. Appellant is further directed to file an affidavit of service on the returnable date.
And left. It's in item number 26. Mr. Rahman is there. I am for the appellant. Now, we both are not willing to do the matter today. So it can
Let
be
me
taken
call
up on
out
Wednesday.
let me call out.
Okay.
Let me call out. Yes, call the matter. Call the next matters. You are for the insurance company. Respondent. Let me appear tomorrow. Day after tomorrow. Very well. Item number 23, day after tomorrow. Next. Day after tomorrow.
26, Mr. Rahman is appearing for response. My lord, day after tomorrow.
You are the appellant.
I am for the appellant.
You are for the respondent. Paper books are ready.
Therefore, there is only one difficulty my lord will face while I will face this matter. That here in this case, what happened is, so the charge sheet has also been filed in 40, but the tribunal was exonerated the other way, and the appellant was the entire liability was carried.
Now, Mr. Rahman's client would get the amount, whatever it was. I will tell you, it's a 80 officers, so the payment can, but as far as the officers are concerned, then the tribunal has to decide proportionally what extent they will have for the accident, what's that extent what they will have. My guess is that the entire liability has been passed on, whether they should have been on. But for this, my lord will be required with the criminal case proceedings. Unfortunately, I have been pursuing my clients to get this, but what I have learned from this is that they are not able to track the entire criminal proceeding that is required. When it's clear that they have analysis, I will be placing this, my lord.
So you are ICICI number
Yes, there is an
and Indian insurance companies.
sorry,
So you have to serve the notice upon them.
exonerated and they have not, whatever they are not required by the government.
They are not met by law.
Oh, they said the tribunal held that they were not required, the entire liability is met.
No. Regarding the third party claim, you can have the claim. So you have to serve a notice.
But how
Notice
can
of
I, my lord,
appeal.
if they have not been treated as a party in the tribunal?
Without hearing them, how can I?
In the appellate stage, if they are not a party, how can I serve? If they are not a party in the tribunal.
Have you
That
raised
is
this?
what I have challenged.
Have you raised this issue?
Yes, I raised this issue to the tribunal.
Before the
but I raised
tribunal?
the judgment. Yes, the judgment comes. Then my lord will take the. And place it on notice. Come back. It's very difficult, madam. Because that is what I have challenged. I have said that the charge sheet says 2 vehicles and you have exonerated them without the trial.
So for your dispute, the claimant is suffering.
Yes, I understand that. In that matter, may I just humbly suggest one thing? Mr. Rahman can make an application as to 50% I am owed. Well, if my lord is of the view that I am only entitled to liable to 50%, then I cannot take it. I cannot recover it from him because it's not money. My lord, can you understand and appreciate that other?
I have
How can
understand.
you recover it from
I have already understand the issue. The issue cannot be settled here. Issue can only be settled before the tribunal. But for that reason, the claimant cannot be suffered for another 10 years. You may fight with each other. The amount deposited, you can withdraw entire amount and you can fight there. Remand back the matter, you can fight there for your portion. If it is appears that you are only liable for some portion, so you can recover the rest portion from the other insurance company. Yes, you place the matter. So the question is there, that whether you have raised the issue before the tribunal or not, whether there are any separate specific pleading on your behalf to the. This is the issue. If that be there, then I can pass that. Call next matter. So it would be
Wednesday.
Wednesday. That means day after tomorrow.
Yeah, I'm good.
Day after tomorrow.
My lord, I am appealing for the appeal, my lord.
32.
32. Yes. The Babu is ready, my lord, but company not appear.
You are for the
Appeal.
appellant. Which for the company?
Bajaj.
Bajaj Alliance.
Yes, my lord.
Who is appearing?
No,
Give me the papers.
I will ready. Mr. Singh.
Let me see the papers. Who is appearing? Let me ascertain whether Mr. Singh is at all appearing or not. Mr. Singh has taken leave today, as because he was engaged for entire first half with me. So I have given him leave for the day.
Yes, my lord.
So in that case, it may appear tomorrow. No issue.
Yes,
We can confirm. Let me see the paper. Yes, Mr. Rakesh Singh is for the response. Not today.
Yes, my lord. I think I'm ready, my lord. Actually ready. Both are ready.
Yes. Give me the paper book.
Then
What is the ground for appeal?
my two grounds I have mentioned here also. First ground is the permit. Second ground is the
First ground is
permit,
permit.
root permit. And second ground is the quantum compensation not followed by the financial judge.
MSc Tribunal Second Court COD Birhum
Yes,
passed in 2013. So you was awarded 10 lakh.
yes. Again the owner.
Against the
Owner.
copy number 1 Ossini Tiwari. Ashwini Tiwari was served.
Yes. Every charge is there. Yes, I served every.
No one appeared on behalf of respondent
No.
number one.
Now, first of,
Let me see whether it was served or not.
yes.
Yes.
Well, at
Sir.
first, go to the judgment, page 45.
Got it.
Page 45. He looks. Vijay Mukherjee, father of the victims. Mohua Mukherjee, sister of the victims. Under section 163, 63 and advised by the Vijay Mukherjee and Mohua Mukherjee, sister of the under it on 26/4/2013, National Insurance Company Limited claiming compensation amounting of rupees 10 lakh for the road accident caused upon the victim, namely Ajoy Mukherjee, by the offending vehicles Tata Truck bearing number W37B 00223. The petitioner case in brief that on 22/2/2013 at about 10 p.m. while the deceased named Ajoy Mukherjee was going towards the Borsula Tikarapara by riding a motorcycle from the Mansuba petrol pump by NH60. When he reached near Kendiakuta at Mansura Mode, at that time the offending vehicles Tata Truck bearing number WB37B 0023, which was coming from the Rampura towards Mansuba Mode in rash and negligent manner with excessive high speed dash against the said victim, as a result of which she received serious bleeding injury, and thereafter when he was shifted to Rampura HG Hospital, he was declared dead after examination. Petitioner case is also that in respect of the said accident, criminal case was started at Rampura Police Station, valid Rampura case file number 36/13 dated 8/2013 under section 279 304A IPC against the driver of the offending vehicle for rash and negligent driving. At the relevant time, the age of the victim was about 48 years and he was on 1,55,002 for assessment year 2011-2012 by doing Bokhari business of stone chip. The petitioner have paid for compensation of 10 lakh only. The petitioner claimants has impeached the National Insurance Company as office by Jeopardy party to contest by filing the written statements on 18/1/2014 inter alia, sharing all the materials point of compensation petition issue. Only 3 issues has been framed here. No issue has been framed which is a permit or not. 3 issues: is the case maintainable? Whether the offending vehicle's flag by number was involved in the accident? Are the petitioner entitled to get compensation? If so, in what extent and from? 3 issues has been framed. Nothing issue has been framed. Violation of the policy. No permit, no deal, no deal. After that, decision of the all issue has taken up together for convenience and heavy and gravity of the discussion from the side of the petitioner claimants following the witness I examined. PW1 Vijay Mukherjee, PW2 Said Rabil Alam, PW3 Basat Kumar Roy. From the side of the petitioner claimants following the documents are produced are marked exhibit. Certificate copy of FIR, certificate copy of charge sheet, certificate copy of two-seater list, photocopy of insurance policy, wherein method, attested copy of postmortem report, photocopy of the voter identity card, Ajay Mukherjee, Exhibit 7, photocopy of the income tax return assessment year 2009, 10, 11, and 9, 10, 10, 11, and 10, 11, Exhibit 9, Exhibit 10, 10, 11. Written argument by as well as by the cited recent oral testimony, exhibit documents of both sides. PW1 be the one of the claimant corroboration the claim petition in his court exhibition on 29/8/2014. PW1 stated that he was hurt of the state accident in question. PW2 reports that he saw the accident which took place on 2013 in his court exhibition on 29/8/2014. PW2 said that he was at distance of 10 to 12 feet from the place of accident. PW3 reports that 13/11/2014 that presently he was posted as the income tax officer. PW3 produced the income tax returns submitted by the Ajay Mukherjee between the assessment year 2009-10 amounting 1,36,780. Exhibit 8, income tax returns submitted by the Ajay Mukherjee assessment year 2010-11 amounting 1,52,572. Exhibit 9, income tax submitted Ajay Mukherjee victim of the assessment year 2011 to 2012 amounting to ₹1,53,062. Exhibit 7. In his court exhibition, he stated that the amount mentioned in the return is nothing but self-assessment of the asset, and he did not make any inquiry in regard of the state assessment as it is not required. PW3 further state in his court exhibition that he did not make any inquiry in regard of the assessment of the state assessment, so he cannot say further whether the amount is stated in the original income or not. Exhibit 1 to 3, 3/1/4 speaks involved with accident of the state vehicles. From the exhibit document, namely Exhibit 5, is revealed that as of said accident, the victim was 40 years old. The Exhibit 6, it is photocopy of the voter identity card. It is revealed that on 1/1/95, the age of 30 years, so at the time of death on 2013, the age was 48 years. As per law, the document which is marked Exhibit 6 admissible by the age of the victims at the time of death is considered 48 years only. According to multiplied 13 will be taken into consideration. Exhibit 5 speaks the date of victims. From the exhibit documents, namely Exhibit 7, 8, 10, revealed that at the time of accident, the victim submitted income tax return assessment year 2009-10 amounting to 1,36,780. For the assessment year 2010-11, the amount to 1,52,572. Exhibit 7. For the assessment year 2011-12, the amount to 1,53,062. Exhibit 7. From the exhibit document, it can be sum up that the victim is to earn down about 1,44,000 down of per annum. According to monthly income taken, approximately 12,000 as by mathematical calculation. Now, it is also noted that the exhibit 3, that is the Caesar list dated 12/3/2013 in connection with Hon'ble case number 36 of the 13 dated 8/2/2013 speaks the insurance policy because of valid up to 11/7/2013, but the state had valid permit up to 28/5/2011. No valid route permit the state of any vehicles has been suffered by the party, showing that the very fact that on the date of accident, state of any vehicles had valid route permit. On the contrary, Exhibit 3 states that the date of accident, the operating vehicles had no valid permit. The question in regard of the permitted route of the line of the opinion because dean was not raised at the time of evidence by the other side. This is the question you will ask. Question in regard to permitted route of the line of opinion because was not right at the time of evidence by the other side. But as because from the side, the petitioner document marked Exhibit 3 was produced and the same spec that the said Tirak opinion was valid permit 28/5/2011. But Exhibit 4 speak that the insurance policy of the petition was valid at 11/7/2013. So petitioner cannot claim compulsion if he interacted same from the said insurer. Now the question, thus is the question. And the calculation of summary calculation here multiplied here. So award cost against the owner of the tickets. Just calculation, summary calculation here. 3 years calculation summary here, multiply. No future cost has been given. Now the question arises. If the 149 depends, 149 depends. This is the 149 depends. In property. But I am the third party. I am not. If the policy is valid, insurance bound to pay the amount in favor of the claimant. If policy is violation here, must be proved by evidence here. By the insurance company and recover from the owner of the case. Now the same question arises because our court, same cases here. I put the same question. Honorable Justice Sanjay Banerjee, Suhakos. Same question. Owner, root permission none given, run a tribunal of the assumption, award pass in against the owner. I file at it because the owner. Is the Honorable Justice. 2 points. Yes, other permit not valid, which is what is the and quantum of option or is I'm marking the point. Now I'll list another point. Two. It is the second ground. The first, the question of the claimant submit that the compensation awarded by the award June 30, 2015 is submitted, though compared to what the claimants are entitled. The claimant also suggests that there are no question of tribunal absorbing the responding insurance company of its liability under the contract of insurance. Third ground. Second, third ground asks that the appellant on the account of low interest rate of 6%. The second ground which is taken up first. It is evidence from the input award the original permit has not been filed in course of the proceeding before the tribunal commissioner. The insurance company apparently obtained a writing from the relevant regional transfer officer to effect that the permit are not one or with the issue of the state officer. However, it does not appear that either relevant RTO or any person office or examine the insurance company or even someone to give evidence in such regard. I refer to the judgment in your lordship, Kamala Mongol versus Banet, United India. The judgment is there. This is the judgment will follow the before the tribunal court. Whether the amendment is valid was valid permit on the was on the claimant held no. It is for the insurance company to establish there is a breach of policy condition and it is not liable. Therefore,
Yes,
therefore. So the violation of the terms of condition, not burden of the claimant.
yes,
Claimant only third party claimants, if the policy is valid,
yes,
I can write to recover policy record from the company. And if the policy violation is there, company is then pay any recovery from the owner. This is the policy. Even the GL, in case of GLCM is there.
this is one issue. And second issue,
Second issue is quantum compensation. Your quantum of compensation is a income tax paying, not for the honest judgment is there.
not following the pronunciation.
Yes, your lordship.
So, regarding the monthly income, you have accepted.
No. I have this decision is there. Same decision there. I can submit the decision. Lordship, I have submitted three years income tax return. Just you can follow the judgment.
Yes, you submitted 3 years income tax return,
Yes.
and
I can
it was taken as 12,000 per month
no.
by
As
the
per last year-
tribunal.
No. As for last year, even the Justice Sanjeevani judgment, I have submitted 3 year judgment, 3 years income return. Last year, you can take it.
Last year has to be taken together.
Yes, my lord. Same follow, same,
Refer me the paragraph or page.
you can. Para 4, as per the first ground of the appellant, the appraisal income of the victim was not taken into consideration. It appeared that it has not fell into error. It evident from the input award itself, the annual income of the victim was ought to be proved on the basis of the 3 set of income tax return for the year of 2005, 6, 6, 7, 7, 8. That the disclosed income of the victim 206, 207, 208, 3,48,970. It will be taken, right? No.
So the assessment year 11, 12 is to be taken.
Yes, my lord.
1,53,062.
Yes, my lord.
What is the income tax given on that year?
Income tax return has some exhibit 6, exhibit income tax, exhibit 7. Not taxable, my lord. 2 lakhs. Exhibit 3, exhibit 9 is lord. You can't see the exhibit.
Page,
I can see. Okay. $39. $38, your lordship, assessment year 2010, 2011. 2010, 2011, 1,52,572. Tax me.
Yes,
My lord, same view was taken by the Honorable Appeals Court, my lord. Para 10, 3 years income tax return submitted, last year they accepted. Para 10, para 16.
para 10 of what?
This is admitted. Para 10, para 16. Para 10 mentions the 3 years of last year.
Yes.
So
Multiplier is 13.
you lordship,
Multiplier
multiply you lordship, taken as
13.
13. What is my lord? 13, my lord. 13, my lord.
And what would be the deduction?
Deduction half as a bachelor.
It was taken 1/4.
No, wrongly. I have submitted wrongly. Not only one. Half. Bachelor.
It will be half.
Yes. Future profit taken in lordship. $25. $25 taken in future profit. Lordship.
25% to the future prospect.
Yes. 42, 45. 42, 50. Self-employed. 42, 50.
Yes.
But Insukum will not file in any court.
Any?
Insukum will not file any court. Any court. Not filing court. That father and sister are not in that. So no question आएगा.
This is your submission.
Yes or no?
Anything to submit?
No, no. This is a
That's
submission.
all.
Insukum will not challenge the element. Not submission done court. So I care for the my grounding.
Being the respondent, they have the right to argue. Yes. Yes.
Starting, one thing I would like to say, that is, the award was, I was totally exonerated. So there was no scope for filing or anything for like that. I was totally exonerated. Now, my landed order, the other side is trying to shift the entire burden of it. So I have got the right, my lord, argue on all.
Have you filed any application under section 170?
Yes, sir.
then you have the right.
Now, my lord, first point. First, my lord, I would like to come on one point which my lord has raised. Ultimately, ultimate point raised by my lord. That is the last year income taken into consideration for calculator of the. I am starting from the last year. So far as the income tax returns are concerned, my lord, accident took place on
2nd February.
2013.
Yes.
Now, my learned student has stated that the last year, what was the last year? I'm showing you the notes from the paper book itself.
Page 39.
My lord, this is the, this is the, my lord, explanation has not been done. The public service part of the evidence of the income tax officer, PW3.
PW3.
I am an income tax officer.
Just let me find out. PW3.
PW3.
Yes.
I am an income tax officer presently posted at Shivli. The income tax return submitted by other Mukherjee for assessment years 2009-10 amounting to such and such marked as exhibit 8. This is the income tax return submitted by other Mukherjee for the assessment year 10-11 amounting to such and such marked as exhibit 9. This is the income tax return submitted by other Mukherjee for the assessment year 11-12 amounting to. Here we stop. Accident took place on 2/2/2013. That means that year comes under the assessment year 2012-13. Now, my lord, another thing process mentioned, the amount mentioned in the return is nothing but self-assessment of the SC. I did not make any inquiry in this regard as I did not make any inquiry in this regard. The assessment of the, so I cannot say whether the amount stated therein is the original income or not. My lord, the assessment order has not been filed. After filing return, one assessment order was passed. It used to this part for anything. But here assessment orders are not used. Now, my lord, kindly come to the income tax return for 9th. Next, it has been filed on 2nd March 2010. It is scanned.
Yes.
Yes. The return for 10-11 because it has been filed on 10th March 2011 and it shows that
Yes.
hard return and those two returns are accompanied with balance sheet. But third return is not accompanied with the statement. And this return was filed on 21st March 2012. Now, my lord, from 1st April 2012 to 2013, that portion is the last income. So, the claimant side has totally concealed that income. Why I do not? That means either his business was stopped or he didn't earn anything at that point of time, that and what we do, what generally what they have family members of deceased, their duty is file who are claiming compensation. Their duty was to file an income tax return on behalf of the deceased after 31st March of that particular year. Because of the last year, he must have earned something so far as their contention is concerned. So this amount should be considered as zero in the last year. So if the judgment which my learned friend has put that last year income will be taken into consideration, that amount is zero.
No document is produced.
Another thing is that
There is ups and downs in business. Anything can happen. So, my lord, what calculation of average? These 3 years, for 3 years, if your lordship wants to take 3 years average, then 10, 11, 11, 12, we taken, and 12, 13, taken as 0, and the total amount should be divided by 3. Here, 3 years income they have taken. 3 plus 0, 3 years income plus 0, and the total amount should be divided by 4, not by 3. In order to come to the actual income, my lord, last year income should be taken as 0, and prior to last year and prior to that last that year 9, 10, 11, 11, 12, and taking 12, 13 as 0, and thereafter the total amount, the total sum should be divided by, means total sum means 1,36,781 plus 1,50,572 and 1,52,062 plus 0. And this total sum should be divided not by 3, by 4 1. It's 4 years income. What prevented them to produce the last year's income? That means last year's income was 0.
Yes.
So it is 4 years income, and the total should be divided by 4, not by 3. Now, my love, that will come down. Total amount will come down.
Anything?
Now, my lord, in the claim application itself, it is stated that in the claim application, in the beginning, we Vijay Mukherjee, son of this Mohua Mukherjee, who hereby apply for compensation to the date of our bachelor. So, bachelor means it is admitted fact that bachelor of the bachelor. And my learned friend has already stated that according to Pranasheti, 50% should be zero. Not 1/4. That is a mistake made by the law. Now, regarding dependency. I'm coming to their evidence. Evidence of PW1. I Vijay Mukherjee, son of this aged about 50 years.
Evidence of
PW1.
Yes.
Cross examination. Sorry.
Yes.
I had got a business. PW1 is the brother. Brothers and sisters are. I have got a business. I earn 7,000 to 8,000 per month from my said business. I am not dependent of the said disease. Mohua Mukherjee is my sister who got married. It's not a process.
Yes.
Page number 2. I am not dependent of the said disease, and Mohua Mukherjee is my sister who got married. That's it. So, why not the claimant, the claimant number 1, and on behalf of the claimant number 2, it has been clearly stated that they were not dependent of the standard. Again, my lord, kindly come to my lord. Chief of Peter. Another thing I want. Paragraph number 5.
Yes.
That my brother was dashed by a lorry truck bearing number WB 37P when he was borrowed
shall Kara by a motorcycle at a track with the first Monsuba or and dashed over the motorcycle as a result of which my brother is in serious and he was shifted to his hospital Rampuha and died shortly. This they have stated the G. Now in the cross examination second para. Second para line number 5. One, two, 3, 4, 5. I cannot say the track number of the meeting. It's not where this is not important. It is not a fact. I cannot say the track number. So this is contradiction. The chief stated that the cross is setting that he has no knowledge about the number of the meeting. Thereafter, my learned friend has stated that insurance company has not argued anything about, has not raised this permit points. Kindly come to next slide. It is not a fact that the said track in question has no road permit at the time of the election. So surely the question of road permit was asked. So that point was definitely raised by the insurance company.
Yes.
I have not no paper to show the income of my said brother. Now, I think on the next that is for the accident which occurred near India Kata Mutsuamo in 1860. To continue, that the fact that the disease was going towards Parasol by driving a motorcycle, rider from number this, which was proceeding toward Mutsuamo from Rampuhat, was being driven on excessive high speed dash and negligent driving by its driver and collision of the vehicle. Thereafter, face to face. I want to give emphasis upon this point. Face to face.
Yes.
As a result, both of them substantially fell down on the road, and the vehicle of fire brigade admitted them and this. Now, my kindly come to the process examination. Here, in the chief pilot, the witness has stated the process examination. I have not got any support from the court. As per sayings of Vijay Mukherjee, I gave 11 number 1. I am a resident of Rampuhat town. I came to learn about the state of Mukherjee after the accident. I cannot say the number of the motorcycle and the track in question. I witness. My witness is very in cross examination that I cannot say the number of the motorcycle and the track in question. Yes, what type of eyewitness? Because Mukherjee was riding on that motorcycle at the time of the said accident, along with Vijay Mukherjee, another infant was with him. But I cannot say the name of this infant. The state motorcycle and the lorry collided with each other face to face again. I was at a distance of 10 to 12 kilometers. 10 to 12 kilometers from the place of accident.
Yes.
Now, at the time of accident, my lord, 10, and within this 10 kilometers, he could easily see the number. Yes, stated in the see, in process examination, you cannot say. So it is not a fact I can say that it's a fact that as per saying of it is not a fact that as per saying of the fact that I have seen that again another thing. is not a fact that I have seen that. I have not seen that. I have not seen that. The learned judge has recorded it. So definitely, he has stated this particular line that I is not a fact that I have seen that. Yes, it is not a fact that I have not seen that. Okay, my lord, this face to face I am not discussing about this. Because there was every possibility of that on the part of the there was, my lord, I am definitely saying that there was when my lord one bike is going and another vehicle and a truck is making the responsibility is upon both. We have heard that. So there was definitely one another that I say that the negligence of this motorcycle rider. Yes. Now, I have considered negligence. Another thing is that why I am saying delay to fire this particular thing? Because I am finding out the fire. Formal effect. 45 copy of formal effect. Right, copy of formal effect. Got it. Yes, Saturday, 8 from 13. Time period about time of information. Direction number 5. Place of occurrence, A direction and distance from BS. Distance from BS is only 3 kilometers. Only 3 kilometers. But the fire was lost. The fire was lost after some 6 days. Yes, here it would have the distance between the place of occurrence and the police station would be in 50 or 40 kilometers. It happened in the remote areas, but only 3 kilometers. So taking the information for such a long time, it is not illegal. Why I am saying? Thereafter, my lord, page number 10, the list of not place based number 36 and all. This is the list in which the clock was fixed. Page number 10. Yes, here. Next page, my lord, page number 8. Clock hearing number. Yeah, the clock. Yes, tweets, which has been made at the beginning. Its number was 37B002. I will find it in the claim application. WB37B002. That now? Yes. We are in the second figure. Car number 8. What track bearing registration number? One of which track is WB57A 002. Where it is? WB 37B. And it has become the figure is 57A. 57A.
Yes.
Now, I will kindly come to the chart sheet, page number 30. Page number, sorry, our chart sheet continuation, page 14. Page 14, para number 5. It is the continuation of para number 10, my lord. Details of properties and articles documents recovered seized during investigation under this section. Previous page, last para. It's under this heading.
Yes,
The
yes.
properties articles. Here in the chart sheet is corroborating seizure of vehicle number WP57A0023. Page 14, para 5. One truck number WP57A0023. The truck is WP570023. Its RC book cannot be of WP34, 37. If it is 57A0023, seized vehicle is WP570023 according to seizure list and also according to the chart sheet number. But they have included WP37B0023.
Yes.
So there is whether this truck was at all involved in this accident, that is questionable. Now, my lord, now, my lord, I will come to the insurance policy. Insurance policy dictated by the claimant side. Page double insurance policy. Now, I want the page number.
And that's the bottom portion.
Yes.
Policy over you don't on the apartment. So farming is essential. And in absence of farming, it amounts to violation of insurance policy condition. So, work from farming was not ready. From the just army of the state army number agenda carried out to SBI file accident adjustment. Army of state army number was held up in from the Caesar list is here. The concept that we have made when the vehicle was flying to the front. Just then It's the party of the that means the party was on value. And according to the insurance policy conditions as told, the certificate of insurance under policy, the under policy condition under the limitation as the policy was equal to the other party. Yes. And the party was not valid. So the one of the week really correct. One of the things supposed to know that we got the vehicle was there was no different experience. And why not? 48 years as you were because why and thereafter why not income regarding income, last year's income, and it shall be divided by 4, I don't know. Because last year's income we considered then why they are not daily, why they are not getting any income. That's why last year income we considered as it's a there is local income that I don't have a calculation on it. You do any reason, there was ups and downs of the business. That will be taken into consideration by dividing it 4. And for that, that is according to the internal according to the cross examination, then we must eyewitnessing there is the interaction of the exact number, and there is contradiction in the one of the vacancies. W57 according to the charge sheet and according to the season. Yes. There is a 57 and the document which is in 37. How is it possible? And the stated that amendment 50% should be deducted as because the bachelor is examining a factor. They have stated the clarification itself that is and the theory by without any basis, nothing like that. Why created by because it is only 3 kilometers from the fire, normally 5 kilometers. Based on occurrence and on the next day, it would be one police station books. Yes, there is a possibility of some of the they were not given I want to find minus this one. Putting it on the link, it's really, it's not properly. What we can is that non-road of the team, whatever the problem and brother villager, except now around half, only 50 lakhs out of it. From 1,20,000 1 crore 50 lakhs, 50 lakhs whatever. not forgiving.
Now, what is the observation? Show me the judgment.
It's what I'm done. When there is any ground for having moments, what amount that person is not dependent, he or she self. No matter if there are number 6, my lord,
Yes.
there are number 6 of the judgment. Unfortunately, due to tendency of the application, the original claimant passed away on 7 in 2016. On his death, response number 1 has died for subscription and such application was allowed by tribunal. The response number 1 was dead in present as only surviving year from the original claimant as well as the tribunal heard that claimant against the owner of the vehicle and its insurer. They issues upon requesting the originally faced. Bearing in mind substitution as referred to above the issue as to whether the response number 1 claim compensation about wastage claim application or considered the right of verification on right to the compensation. The design of the fixer, what is the code of state of compensation? How not asked us that code. The tribunal considered the response number 1 as a full surviving here and here. The tribunal, upon discussing the evidence, was laid without finding that disease was immediate of the accident, and that already it was given as well as second. Now, finding out the only point based on business team that the respondent number 1 being correct sister of the disease. Yes. Direct sister of the disease and not being dependent on the system at the time of the state, and there being no evidence for us. Not surviving the income and loss of the no amount could have been awarded on that date, and the award amount is not from us. At all, the respondent number 1 was considered for loss of the state, and that is referring to the various systems of the export by him. That has been done that. And then the object of the terms of says chapter 12 of that act that the claimants in the same position as far as money can add the victim not suffered by therefore plus compensation that the respondent number 1 is not a bonanza arising out of death of her elder brother or who was not connected. Was contended that of dependence does not include marriage sister and therefore subject not to be or in mind while citing that. It's this should be a fortune out of misfortune. For a non-dependent person, getting certain amount is fortune out of misfortune. Now I'm turning down to paragraph number 24. However, for concluding 24 There's a very important point. He pointed out that we have facts of the response number 1 not being independent on the income of the receipt, not warrant production not intended to Indian except on account of loss of estate. According to him, the response number 1 was from each other in unfortunate accident. There has been no reported decision on the aspect of loss of power condition here, and the company that suffered by one time the death of one father at times of need, the father's shoulder that square good for the rich. The loss created by the backlog, according to him, is one fact by the tribunal and report by the state backlog.
Yes.
Second, my lord, for this. Canada, my lord.
The unfortunate accident will explain the covered and this considered the first point that of the present. That is called at the end of the they were from the very beginning. They were not, you know, in particular. But my lot of people, I guess, they start. But in our case,
So where is the observation?
Avoid is not throughout the practice of the character
Yes.
has not been questioned by Mr. Singh on the ground and the calculation of the other hand. It has been asserted by the that is one number one. Not being educated on the difficult amount of function is quite a factor. The results are not and being around people in product, not alone for this contention implies clear equation that had the love limit is alive and is still argument.
Were over thereafter and the against tribunal had awarded a sum of small total and appeared to have no cause of defense. If he had been alive, the original agreement, he would have been entitled to whatever he could as on that day, and the claim application was repeated. This was not a case where one dependent legal the difference between our cases. Approach the tribunal, on the other hand, was dependent. Then was the other as heir of the claim. He had passed away immediately on the document were both most of the one who had been expected to award possibly appellate may not have valid reason. This claim, even if such situation is only because of their proceeding on the argument that the result of the one's claim to compensation. In our case, while it is true that compensation awarded under this one's claim from the that cannot be a problem of dependent on the victim of the population. We found out whether the date of the claimant is used by an insurer as a regard to secure a people in or needs, or in other words, the date of the claimant to come at the moment of is not considered the law. So the law must be applicable alike all the parties of presentation. Party and insurer that its own contractual liability must by taking care and avoid that of its own act or omission. As typically for other reasons, conflict the partner not to cite the main officer. Expedition, inevitable casualty, consequence to the justice, shall be tied to the no party allow keep the victim of the not by condition of the content here, justice. There is the party of the own of all this and those that's now, my lord, para 51. Para 51.
Yes.
It is true that the compensation for loss of love and affection and guidance that would have been showered by an elder dies in a motor accident on the member of the family is not expressly provided for the 94. However, the same time, must be remembered, section 168 of 1980 that speaks of just compensation of tax and in circumstances of a given case, not a specified amount under different dates as one defined in section. Although the compensation for loss of estate, loss of consortium and are being standardized in ownership, such compensation must be just that's of the case and not any arbitrary fanciful amount without having an extra to the extent of loss of extra loss of our brother is measurable. If the brother who always be there when the sister needs it, the brother will be the partner and all. Be the brother's shoulder of each rest for turmoil in a life. Since 1988, Act does not specifically provide how compensation is to be asserted as to be assessed. It is for the tribunal to hold hands during the case. It is not chapter 12 of 1988. Section 168 thereof has left the matter of the discretion of the tribunal. Of course, here motion have to be exercised by the but statement of frustrating. The purpose of compensation is no amount were awarded under this particular date on official consistent ground that has been increased and does not find for but nothing were to be accepted. No amount would be awarded for the complaint or amount of that means the same is visible only in section. Not for the application of the we does hold that issue has to be answered in the light of the facts of the now, if you know my law,
I will give in our initial consideration to the facts of this case. We are inclined to the qualification of the award of responsible and award of 50 lakhs rupees are the entry of the order accordingly that is accepted, but the state amount set can be discussed.
oh my lord, since the
System of not according to the company is what
was not dependent, but the master is not. I the case, they were dependent. So my lord, the master. All cases, I covered 40% of the 1 lakh 50 lakhs of the 1 lakh 1 crore 20 lakhs something is 40% already. But I calculated 40.7%.
No, this is not for that ground. That ground has been set aside. That ground raised by the Mr. Singh has been turned down. In the specifically turned down. The just compensation was awarded by this court, by the division bench, that is 50 lakh. That is another issue. But the issue raised by the Mr. Singh has been consciously set aside. So you cannot raise this issue here. Your submission is separate that they are not dependent.
They are not.
Yes.
They are not dependent, so they are not entitled to get compensation. For the
Yes. Yes, anything?
so dependency, my lord, definitely dependency is a factor. Determine the
Yes.
quantum of compensation. And the difference between this case, we have discussed and the case, that
Yes.
this merit system will inherit the award is not taken before the father.
Department of the as being non-dependent, not limited. Not in the life of my husband. Yes, it's not limited. Not in that. Now I people who are they are not limited. Yes. Anything? So once the kitchen can be it's still not evidence. Section 8. It is no other guide. In the other place, it is under section 166. So in the charges report, legal aid needs the all section. No evidence. Typically means other of the digits is individual population here. Other of the persons who died in a motor vehicle accident was entitled to maintain the petition under section 1. A of the act if you are the legal duty of the digit. So in the judgment Supreme Court says para 2, the vehicle that on account of the negligent part of the driver, one boy 15 years died ran off the bus. From by and years by the father of the disease, he issued petition. The English sense is there, the petition was maintainable, and para 6 also mentioned that Indian Fatal Action Act 1855, for that they are almost identical insofar as the persons who was the benefit action for the compensation could be brought on the death of a person, and there are wife, husband, parents, child of the deceased. The English law was however modified as far as the above question was concerned. That action case 1959, section 1, for that the person's benefit by whom action brought in the case shall include the person who is not, who is the issue of father, sister, uncle, aunt, and of the deceased persons. Details para 6 is tricky.
Yes.
So last para also mentioned the interest. Another case, your lordship, father died in charge assembly. Father died. Father of the churches assembly legally busy. Charitable
Yes.
section 66, date of the father belong to the appellant society in a motor vernacular accident, whether applicant society file an application who father died in accident. This case has maintained also. Legal representative means definition, para 5. Para 5.
Yes, para 5.
All are definitions. Sons, both sons are earning member, adult, no dependency area. Para 8, madam.
Para 8.
Yes. Mother-in-law. Mother-in-law. I claim mother-in-law. Para 6. Attached with my ears. Mother-in-law. Para 6.
Yes.
मेरा delay है calculate high delay justice
Not necessary.
no need.
Okay, you submit. You have collected, you submit.
Mr. Police Tendon.
Just wait. Let him finish now.
Para 8 and 9.
Yes.
That's all.
Why am I talking? But it was the purpose of trying to keep the right of the parent.
Yes. That's all right. I don't think that's a good idea. Basically, if you can ask people for the time that book, evidence. Just that is not mentioned that for you. I will not like. At your someone will teach you, and it will be some company will teach you that that is what a punishment for you. I am not very excited to judgment of justice balance. It's not so. I guess I will have responsible. One on I have the fund. Even though yes, I got that also the articles. At a glance about the fund. So this is reported in 2004 SCJ 209. I can put on the report, I got it. Second topic is the
Yes. Please take down. Yeah, for the package. Let's see. Next. Yes, Mr. Singh is for the appellant. Tomorrow first matter. Yes, sir. This matter at 137 appearing in the list altogether for 4 days, but could not be taken up according to government advocate for the respondent. Seek some accommodation. Let the matter be appeared as a first matter in the first matter tomorrow. Third hearing a first matter. I do not have this. But that's all better.